Committee Room 30. Sound.
I welcome members to the 55th meeting of the Committee for Justice. Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online. Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rolls. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that oral evidence session will be with the Permanent Secretary of the Department of Justice and the session with departmental officials on the Enabling Access to Justice Reform programme and taxation will be recorded by Hansard, and can I seek your agreement for this? Agreed? Agreed. Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interest to declare in relation to the day's business should do so now or when the particular matter arises. Can I ask members if they have anything to declare at this stage? No? Okay, content. So agenda item number 1, apologies. So we have apologies from Danny Becker. Any other apologies? No, I think we're okay. And we have no one coming in remotely or virtually today. Very good. Agenda item number 2, draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday, the 13th of November 2025 are pages 5 to 16 of the meeting pack. Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 13th of November 2025? And if so, I will sign.
Great.
Agreed. Agenda item number 3 then is matters arising. Can I ask members if there are any matters arising from the minutes that they would wish to raise at this stage? None? Okay. Agenda item number 4 then is transforming the criminal justice system in Northern Ireland, Criminal Justice Inspection Northern Ireland report and other matters. Department of Justice Permanent Secretary, oral evidence. Can I refer members to pages 19 to 214 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Hugh Widdis, the Permanent Secretary of the Department of Justice, on the Transforming the Criminal Justice System in Northern Ireland report by the Criminal Justice Inspection Northern Ireland, as well as other matters. The committee agreed to invite Mr Widdis to discuss the report after receiving oral evidence from Sejini on the 29th of May. Can I welcome Hugh Widdis to the meeting? Thank you very much for your attendance, and can I invite you to make an opening statement?
Thank you, Chair. Thank you very much. Committee, thank you so much for seeing me. So thank you very much, Chair, for the opportunity to meet with you today. I know that officials have been attending the committee regularly. I hope you're finding that helpful. Chair, you're very welcome to the committee. Not that it's for me to say, but the Minister said it many times, we very much value the input of the committee. You'll know that I've been before and members of the department come all the time. And I'm very happy to help the committee anytime we can. We're trying to advance the Minister's priorities fairly obviously, but the committee's got a critical role in that, both in terms of challenge and in terms of support. So I know there's a lot you want to discuss. I'm here to talk about whatever you wish, but I know there's been some focus in particular on the Criminal Justice Inspection report on transforming the criminal justice system. So we've given an update on progress, so I hope that's helpful. I'm thankful to the committee for the extra time in terms of coming before you. That was to allow us to progress things sufficiently to keep you informed about what's going on, and I'm very happy to discuss as much as that as I can today. I know the committee is very keen in the shared future vision and strategic priorities to deliver transformation and innovation across the criminal justice system, as recommended in the report, as are we. That is not without its challenges. Everybody will understand the complexity of the criminal justice system. It spans, for example, 2 government departments, not just us, but PPS. It spans 2 different accounting officers, therefore, even in those departments, but also we're talking about operational independence, including the PSNI, the courts, tribunal service, and of course, independent judges, very much part of the system. Lady Chief Justice, of course, is a member of the Criminal Justice Board, and she is very protective, quite rightly, as we all are, of the independence of the judiciary. So each part of the system has critical but very different roles, and many require the essential independence that society and the system expects and needs. The outworkings of that, though, is that transformational change can be made complicated. So in order to make sure we're all moving in the same direction can be difficult while respecting that independence, but we're committed to doing so. The Minister and the Criminal Justice Board are strongly committed to having a shared vision for the justice system, to inform that collective purpose. There's also a consensus that such a vision should be developed collaboratively. It cannot be a Department of Justice vision or a Minister of Justice vision imposed on the system because of all those independence reasons. It must be a system-wide vision which provides a point of direction that everybody can agree to move towards. So we did initial work to develop a division inside the department, and then it was discussed with the Criminal Justice Board in spring of this year. We developed an engagement plan and agreed it with the Criminal Justice Board. And at the meeting in September, the Criminal Justice Board asked for the engagement to be expanded and include some more focused discussions with board members. It was agreed at the outset that it would be beneficial to engage some external input as part of this, again, not to give the sensation that the department is in some way imposing this on all of the participants, but to truly, in a kind of collaborative and co-design way, develop the vision. And we've engaged, for example, with the Chief Inspector herself, we've engaged with the Chief Constable, the Lady Chief Justice, other members of the Judiciary, the Law Society, the Bar, PPS, Probation Board, Court Service, and the Director General of the Prison Service, and perhaps most importantly, the Commissioner Designate for Victims of Crime and victims groups as well. So we're now in a position to have a draft vision which we are bringing to the Criminal Justice Board at its meeting in December. We'll then look at arrangements for a wider public engagement, which is a fundamental step in this process to get it right. We're very keen as well that the committee would have time to consider this as an absolutely key and critical stakeholder in the criminal justice system, and we'll very much value your view as part of ensuring that we have a shared vision for the system as a whole. It's really interesting to note that some of the discussions with the stakeholders touched on the role of the board itself, so not just the system, but what is the role of the Criminal Justice Board in terms of driving that vision forward, and we're very keen to look at that as we agree the vision as well. I think it's worth, as well as what we're planning to do for the future, I think it's probably worth noticing the range of transformation that's already happening across the justice system. And the Chief Inspector recognised this in her report. There's been very substantial change going on. Members will be aware in particular of the Speeding Up Justice programme, which the Criminal Justice Board itself is supervising, fundamental to getting a better experience for victims and witnesses, but also increased efficiency and public confidence of stakeholders. That programme has been developed again with all of our partners, so even in the absence of the single unifying vision, that work has been done. Criminal Justice Board made a priority across the system as a whole a number of years ago that we would speed up justice. We've got public sector transformation funding into that, so I'm very happy to discuss that if members are interested in detail. We've got public sector transformation funding into electronic monitoring, again showing transformation across the department and the system as a whole. And we've put further bids into the second tranche of the public sector transformation funding as well, and I'm very happy to discuss those with members if they wish. The department is actively engaged with the board and the secretariat to the board to assist its consideration, that is the Transformation Board, and we're waiting on the decision of the board in relation to the latest bids that we've put in. I'm really grateful as well then that based on the recommendation from the Minister, the Executive has agreed in June that we can continue with the recovery plan in terms of getting 7 million by way of a first call for policing pay, so that's incredibly supportive in relation to one of the transformation strands in policing, which is the recovery programme, which the Finance Minister has been very supportive of, and the Justice Minister and the Chief Constable are committed to. And I have a few other comments, but I'm happy to leave them there, Chair, and pick them up just in the interest of time and letting yourself and the members get started.
Hugh, thanks very much. I'll put it out to members then. Brian?
Thank you, Chair. Thank you, Hugh, for your attendance. The transforming report from CJNI was helpfully brief in its number of recommendations, just one strategic, two operational. In reading the report we have on that, giving an update, I am surprised that my reading of it is that of the two operational recommendations, no actions are resulting. We're told that PSNI Strategic Transformation Board to review leadership and governance of its transformation projects. PSNI has advised the existing terms of reference cover this and that no action is required. And the second operational recommendation with all the other various organisations within the criminal justice system were to review their operation, review the purpose and membership of various programmes to reduce duplication and release capacity. And we're told in the update that all those organisations completed reviews in May 2025 and advised of any issues arising. No significant concerns have been identified to date.
Yeah.
So obviously this is a transformation report, and I'm concerned that the bodies have had a look at themselves, it seemed, and reported that no concerns have been identified. Is that a fair reading of it? I mean, have any of the organisations come up with any proposals to reduce duplication, to make savings, to speed up justice? Or will that be covered by the strategic recommendation that is underway and has been extended?
Really helpful, thank you so much. There's the strategic level, and that will, in terms of a kind of a series of steps, agreeing the vision first, and then using that to decide A, what kind of governance is needed, B, what the future work plan would be to deliver that vision, etc. And I'm happy to talk about that. But yes, I would anticipate that might result in some shifts of governance. For example, one of the comments in this process has been about the composition of the Criminal Justice Board itself, and whether we might want to revise that and logically speak at the boards that flow to it. On the two operational recommendations, so the first one is very much about PSNI, and we as the department, in order to assist the committee and assist Criminal Justice Inspectorate, will make sure that we pass these recommendations out to PSNI and then we'll flow them back through, etc. But PSNI have looked internally at their governance, which to be fair has probably changed, I think, since some of the groundwork was done, some of the fieldwork was done on the inspector's report, and they're quite content that no further action is needed inside PSNI, because that operational recommendation is very much about them in order to further streamline or reduce duplication. I assume that means, in fact I know that it means that they have actually looked at the groups that they have and they've decided they don't need to change any of those. One of the groups, for example, which isn't exclusively in PSNI but is PSNI and PPS and works very well, is the Working Together Board. And you might find then that under the Working Together Board there's a number of projects, and some of the same senior people in the two organisations would be involved in delivering each of those projects, and therefore might be also involved in those projects on the Working Together Board. But the PSNI have looked at that and they're content that there's no duplication, there's no unnecessary duplication or no harmful duplication in that. And then similarly, because the second operational recommendation is not wholly dissimilar but is wider and across all organisations, and we've asked everybody to look at that and come back to us, and nobody has come back to us yet and told us that they've got any significant concerns. Again, I think the passage of time since the field work was done may have resulted in some of these groups have already been streamlined to a certain extent, but we're not getting anything back from the system as a whole saying that we are finding, or that the organisations are finding, significant amounts of unnecessary membership of, for example, more than one group at once. Mm-hmm. It's probably partly to do with the fact it's a really complicated system, and if we're running multiple projects and multiple programmes across the system in order to try and improve it, because of the fact that, for example, by comparison with the UK as a whole, we're talking about relatively small numbers of people in Northern Ireland, it's both to some degree to be expected that you might get, for example, an ACC sitting on 2 or 3 different project boards to drive things forward, and then reporting back up to the Deputy Chief Constable or through the Chief Constable to the Criminal Justice Board or whatever, as opposed to, for example, if you're across the UK as a whole, you might get an ACC from one police force on one particular strand for the National Police Chiefs Council or whatever, and then another one from a completely different police force on a different strand of transformation.
Yeah. Well, I am left bewildered. Did the groups talk to each other? I mean, because the purpose here was the aim of reducing duplication and to release capacity. You know, did they just look at things internally? I do think it puts more onus now on the department and on the minister to find means to make transformation, to reduce duplication and release capacity. The fact that it seems that the various organisations themselves haven't came up with any actual proposals to make any difference in a report which is meant to be about transformation, and the police seem to be saying, oh, we're getting on with that work ourselves anyway. So I have to say that it's a disappointing outcome so far on the CJNI report. and I think it puts more onus on the department to get organisations to take that strategic overview of who's doing what, where savings can be made, where operations can be streamlined if there is duplication, and to release capacity, which is what we were told this was to do.
So I would very much hope that the strategic recommendation will lead us towards that direction as well as the system as a whole. Inside PSNI, again, we aren't directly responsible for PSNI in terms of accountability to us. The policing board is there, but the internal structure of PSNI, broadly speaking, around transformation revolves around a strategic transformation board which they have in place, and they have a programme of activity. There's, from recollection, 20 or 30 projects inside that. I think I would anticipate that because of a scale of a transformation programme like that inside an organisation such as the PSNI probably relies on a limited number of people who are involved in multiple different parts of it. And the PSNI have looked at that and they've assured us that they're content that there's no unnecessary duplication. On the other one, nobody has yet, the other one feels a bit like this recommendation, but system-wide, nobody has yet told us that they're seeing any particular duplication, but we're very happy to refresh that and come back to the committee, and if we do find something, or even to report generally on why it is people haven't found that, and reassure the committee that we're not unnecessarily putting too much onus on people. My understanding of the report is that it's not really about duplication in the sense of wasted work because two different groups are working on the same thing. It's more about the small number of people who are involved in driving forward the changes having to be part of multiple different governance strands to drive those changes and then report back up. But I'm very happy to come back to the committee with a bit more reassurance about that if that helps the member.
We'll hear in due course.
Okay, Connie?
Yep, thank you. Thanks, Chair, and thank you, Hugh, for coming in today. And I think I wanted to talk around transformation and the pressures within the department, especially financial. And I know all departments have cited financial pressures this year, but I think you can correct me if I'm wrong. There's a particular squeeze on DOJ, that 0.5% of their budget is discretionary, and I just wondered if you could talk about how those pressures are impacting your department's ability to deliver transformation.
No problem, thank you, member. So the department's resource budget as a whole after June monitoring was about 1.4 billion. But out of that, we run the justice system as a whole. Policing, as you're probably aware, takes up about 2/3 of that. It sounds like a very large number, but actually more than 2/3 of it is taken up with the staff costs, and by and large all of the rest of it is taken up with statutory commitments, things the department or our partners must do because the law of the Assembly or laws passed by Parliament require that to happen, or existing contractual commitments. So it makes it incredibly difficult. One of our calculations is that it's about 6.2 million, which is not essential pre-committed spend, which gives us that discretionary figure, which is less than 0.5% of the total budget. So that makes it really, really tight and really, really difficult to do transformation. That's all on the resource money side. On the capital side, because capital is typically an investment in the future and investment in doing things in a better way, very often physically around buildings, or very often around computer and IT infrastructure and so on. So we invest all of that money on a regular basis in order to do it. But even that 100 million is quite tight. And the department has seen our 5-year departmental plan, so you've seen the possible need for more capital investment into Department of Justice over the next few years. And any support the committee can give in terms of getting that would be gratefully received. What we've done, though, in order to try and supplement that is bid in. For example, we've bid into the Department of Finance every time there's a round for coming, and we can speak very positively about being able to deliver our transformation projects on budget, on time, as we've done in the past. And for example, we've bid into the Public Sector Transformation Fund. As I said, we were quite comparatively successful in the last round. We secured 20 million and a few millions of capital as well in relation to the Speeding Up Justice programme, very central to transforming the criminal justice system. And we secured 2.5 million for the electronic monitoring project as well, which will allow us to enhance and modernise what we're doing in relation to electronic monitoring. It sounds like a relatively small amount of money, but when you think about us having a 6 million discretionary spend in the department, actually 2.5 million is of great assistance. That's 2.5 million over a number of years in terms of driving things like GPS facility in the tagging as opposed to just a kind of a local radio thing in the tagging as well. So we keep on pushing what we can in relation to those things as well.
Yeah, thank you, and I think that those projects will be really positive, and it's great that you secured that funding for them. And I just wondered if you could talk a bit more about the context that you're working in and transformation that has taken place to date since policing and justice was devolved to the Assembly.
Members will know I'm still quite new. I suppose I'm a year in, but I'm still quite new to the department and so on. But one of the things I was incredibly impressed with was the quiet history of change and transformation that justice system as a whole and the criminal justice system in particular and the department have delivered over the last 15 years since policing and justice was devolved. So whereas maybe it hasn't always been tagged as transformation or transformative activity, and I absolutely accept the critique in the inspector's report that not everything that might be badged as transformation is actually transformative. But if you think about the prison system and where the prison system was in 2011 before the fundamental review and where the prison system is now, so I was reminded, Permsec of Department of Education, who was previously Director General of Prisons, he reminded me just yesterday about McGabbery being reported on very negatively not that long ago, a decade ago, but now our prisons are amongst the best in the United Kingdom in terms of independent inspection. So Hydebank, you're probably aware, has been scored 4 out of 4 on each of the standards of prison inspection. McGilligan was recently inspected, and I'm very confident that'll go very positively as well. So the prison system has been transformed towards rehabilitation of prisoners and also cost per place driven out across that period as well. Youth justice is completely transformed away. So again, a fundamental review of youth justice and the way we do things there, and a child first approach. So we've gone from something like 40 or so children at any given moment, children and young people in custody at any given moment, down to, I think the last figures that I saw were more in the region of 10, and that's deliberately through a transformation of the way that criminal justice is done in relation to children and diverting them out of the criminal justice system and taking this child first approach. So there are similar instances across the justice system as a whole. I absolutely agree with the inspector about how we can enhance that and build on that and go further by taking a system approach and accepting that people have, or different participants in the system quite rightly have independence protected, that the judges are independent constitutional actors not subject in any way to the control of the department. But that doesn't mean that the system can't be enhanced by agreeing around a single vision, and I'm quite confident that all of the work that has been done before shows that A, people can collaborate and work together, and B, and I suppose adding to this, Criminal Justice Board members' willingness to do it, which they have displayed that they are willing to do it, their willingness then to cohere around a single future agreed state for what the criminal justice system might be like, and then to help their organisations all steer, or their parts of the system all steer towards that. And I think the history of transformation that's been delivered in the justice system can only give us confidence about being able to deliver that in the future. It won't be easy. It's never easy to corral any system into a single direction, and it's never easy, as you say, to do transformation without necessary injections of funding, but we're doing everything we can, and the Minister's doing everything she can with criminal justice leader partners in order to make sure we can deliver that.
Thank you.
Deirdre?
Yeah, no, thank you very much. Hugh, you said the draft vision would be ready in December. Would that be with the committee in December, or is that just for board approval?
So we're hoping to take it to the Criminal Justice Board, which is to happen in early December. In my memory, it's 12th, I suppose, given December is a shortened month for holiday reasons or whatever. Maybe that's mid. But I'm very happy, as long as the board are content with where it is in terms of kind of the core concepts of it, very happy to bring it to the committee as soon as we can after that.
I swear the last committee in December, maybe early January potentially for time.
It's subject to the board agreeing with us on that,
Okay.
because the board is of course the Lady Chief Justice and the Chief Constable. It's not just the department or the minister or whatever. So, but I'm very happy to aim for that and bring that back to the board and say, could we do that?
And just to get a sense, you spoke there around going beyond the board in terms of looking at the vision and going to other stakeholders. Can you get a sense of who, and were victims and survivors involved in that? Because obviously one of the big aspects of delay is just the impact that it has on them. And just to see, and I know Gillen, when he looked at this whole issue, was just around trying to build in, I suppose, the voices of victims and survivors. So it's just to see were they involved as part of that vision and work.
Absolutely. They've been involved to date, and the Commissioner Designate, for example, was one of the first people that we've spoken to, and you're probably aware the Commissioner Designate now attends the Criminal Justice Board, which is a kind of an early iteration of how we might evolve the current composition of the board in order to make it more effective. And as we get through the vision, I hope that some of that would be thought about as well. And we've engaged with victims groups in terms of that as well, and in terms of where the kind of emerging thinking about the vision is and what we're going to bring to the board, the place of victims is very central in that. So there's an emerging theme around supporting and listening to victims and citizens, because the whole system is there in many ways to vindicate the right of victims and to protect citizens in society as a whole. There's also thinking in there about making sure that we do justice at pace and efficiently, and there's also thinking in there about minimising and deterring offending and reoffending. So those are the kind of core concepts which have come out of the collaborative co-design work that everybody feels are the right things that the system should be heading towards. But we simply need to bring that together to the board and make sure the board is content and therefore willing to drive it inside its organisation, and that will very much include making sure that victims are core to the ultimate vision as well.
And I suppose just following on from Brian's points, I mean, I would be concerned in terms of some of the recommendations from the Criminal Justice Inspectorate, because when you read through the different reports, obviously they talk around transformation programmes being fragmented within the wider kind of department and all of those different organisations, and also they highlighted weaknesses in cooperation, and then the accountability pathways. And as you say, there are different, like the policing board, obviously this committee, so there's different strands of accountability as well. So if there's no clear vision, there's a bit of disjointed in terms of transformation, and then also there's no clear pathways, I suppose, in terms of the vision and accountability. It's a bit all over the place at times. So even if you're trying to get synergy, the vision's one thing, but then what that looks like further down the chain from the vision and the accountability around that, how do you go about rectifying that, or what have you identified as key areas in order to deal with some of the, I suppose, complaints or criticisms that the Inspectorate has highlighted?
So really helpful. Thank you so much, Member. I think the Inspector has quite rightly picked up on cases where individual organisations have progressed a particular change project and not fully thought out what the implications might be for the system as a whole. Yeah. I totally accept that, and that is a symptomatic thing across any system. Any big complicated system of what's happening in government will have that. The long move and the long march towards better collaboration, better cohesion across government, making sure we all know what each other is doing, the programme for government itself as a coordinated programme of activity, drawing together multiple outcomes and trying to push everybody in the same direction. All of those things are indicative of, I think, exactly what we're trying to do here as well, which is say one of the ways to prevent that happening, i.e. different projects happening kind of in isolation for each other, is for everybody collectively to agree where we want to be with the criminal justice system. And if everybody does agree that, even though they're all independent and they don't have to agree it, but they choose to agree it, then it draws everybody towards that. So, for example, one of the things we would anticipate coming out of the vision then is that we would have an agreed work plan across the system as a whole. So if somebody wants to do a particular development, for example, some digital innovation in their area, that it's not done unless it's part of the work plan which is driving towards the vision. So there should be no impacts, no unanticipated impacts on other parts of the system or other organisations. And therefore increasingly less of, if that's not an oxymoron, but a decrease in any of the kind of symptomatic individual bits of a system doing their own thing and not collectively thinking about the impact on others.
And I suppose that's the bit I was going to ask, what the next bit of the vision, because the vision's one thing, albeit it's what comes after is the important, because as you say, there's good work being done in each of the agencies in certain aspects, but it doesn't match across the board, and then there's gaps in it then, and there's not a consistency, and I suppose that shows then it leads into why there's delays in the system, because the system isn't taking a whole system approach to things, and there may be good progress in one area but huge gaps in another. So I would be keen, when the committee gets the vision, what is going to underpin that vision. So what is the prioritisation going to be? What's the work plan going to be? And if we can get a sense of a time scale as to when that's going to come forward, because I think it is important on the point Connie raised that, you know, the budget situation isn't going to hugely improve even with the Chancellor's announcement next week. Albeit we are going to be moving to 3-year budget cycles as well, hopefully within the executive. So that leads departments then down to what is it they're going to prioritise, and how can the agencies within the broader justice family work on that prioritisation and that shared vision. So I would be keen just to get an update on that when you have it. And obviously some of the areas, particularly around sexual offences, you know, and the length of time that it's taken. Adjournments, I know, is a big issue in terms of that. But even the victim on the day in the court not being told nearly. So those who are up on the charges are nearly away home. These are some of the cases that I've been, and the victim is still sitting in the courthouse and isn't told until much later, and the case has been adjourned. So it's just the impact that that has on the victim and survivor. And then obviously we know the huge delays, and there was an increase, I suppose, in the amount of delays in Crown Court cases, which are some of the most serious cases as well. So as part of that prioritisation, would be keen to see what areas the department and the kind of broader justice family are going to prioritise over the next period, taking into account we're working within a constrained budget. So be keen to hear more then once we get that vision and document what underpins the vision, and what, I suppose, what's the accountability then around that going forward.
Really happy to do that, and I completely agree with you. You could agree a vision and kind of put it up and maybe print out some nice flyers and be forgotten in them. Embedding it in people's thinking, embedding it in people's strategic planning inside their organisations, embedding it in culture across all of the operators inside the criminal justice system must be part of it. Once we have it agreed as a core direction, the plan is that we will get feedback from across the system as a whole, including yourselves on the committee. Is it the right vision? Mm-hmm. Maybe we'll need to tweak it a bit more. Part of that has got to be about clarifying ownership of it and the governance around it. I know that sounds very dry and tedious, but making sure, for example, that the Criminal Justice Board accepts ownership and is seized of it, or the Minister or whoever it's going to be, but I would anticipate the Criminal Justice Board. And then critically for the exactly what you're mentioning, member, is to get a specific work plan dropping out of it. So again, as with any strategy, you set your future state, and then you draw out a very detailed work plan or a roadmap as to how you will get there. The first few years of it will be clearer and more precise, and the further end of it may be less fleshed out just at the moment. But I can assure you, again, as long as the board agrees with us, that we'll be developing a work plan and bringing it to you. As an example, so the Criminal Justice Board has already, its current priority focus is on speeding up justice. Yeah. That's not a criminal justice system as a whole vision, but it is very specifically a priority to deal with one of the known key problems in the criminal justice system, which is avoidable delay. So and for the Speeding Up Justice programme, we've now a very detailed work plan. We have, as you're probably aware, there are 5 big projects in that programme. Each of them is broken down into sub-strands of activity. We've got a detailed, we've enhanced the governance on it quite recently, partly having received the transformation funding. And we've a very detailed work plan and timeline of when everything is going to happen. And the interdependencies, for example, between direct committal and early engagement fees and digital reform and remit of the Magistrates' Court. So there's a worked out sequence on a Gantt chart of how that'll all happen. And similarly, I would anticipate once we get the vision agreed for the system as a whole, not just the Speeding Up Justice bit, that there will be something equivalent agreed by the CJB and therefore applied across all organisations as a whole to coordinate activity and show the results and show the outcomes for the system and the citizen. And then very happy to bring that, once that's all developed, very happy to bring it to committee and discuss that or explain it or as committee wants.
Thank you.
Okay,
I hope that's reassuring.
Thank you, Chair. Hugh, thanks very much. I understand that a lot of this is very complex because we do have independence in certain arms within your organisation, so I absolutely get that. But there's just a couple of themes, or a number of themes I would like to just cover, and I want to start off, follow on from what Deirdre said about victims and victims' information. Because at this moment in time, we have the Prisoner Release Victims Information Scheme, the Victims Care Unit, the Victims Information Unit, the PSNI and PPS Victims and Witness Care Unit. Surely it makes more sense that we can combine all of these into one victims information scheme, which can cover all of this, than having to go through all of these different ones. Remembering, of course, that we have an opt-in system as opposed to an opt-out system, something I still don't quite understand the rationale for. But because if you just had been a victim of a very serious crime, even up to murder, the last thing you're thinking about is, do I want to opt into a scheme? But they will want to at a later stage. Is there anything we can do to rationalise all of those information schemes? Because I'm going to be honest, and I'm going to come on to this in a minute, they're not working. They're failing, and they're failing victims quite badly.
Okay, really helpful, Mr. Beattie. Thank you very much. Again, taking it from the top in a sense, so once a vision is agreed, I think it's hard to conceive that the vision won't include a future state in which we are even better about what we do for victims and witnesses and citizens. So on the assumption that it's going to be there, and we will certainly be encouraging the Criminal Justice Board to do that, you would then, in order to enhance what we're doing, you would then get an agreed set of detail, for example, about the work plan that I was just saying to Ms. Hargett. And it may well be part of that then that you would review the way we do victim services at the moment, and that you would include proposals for that in the work plan and so on. I find it hard to completely agree that the system in terms of victim information is failing. I know that there are cases in which the PRVIS, for example, has not managed to get the right information out to people, but that doesn't, for me, mean the system is failing. It means that there are individual instances where things have not happened as we would like them to, and I appreciate completely that causes unreasonable distress for victims, but I don't think that means the system is failing. But if we agree a vision in which we say we're going to change the system as a whole and we'll make things better for victims, then I would be encouraging the board and all of the criminal justice bodies to think about how we can do it.
And sorry, Hugh, when I say the system is failing for me because of the lack of cohesion within it. Because the right hand doesn't know what the left hand's doing. Let me give you a very clear example, and I've raised this many, many times. The family of Jim McFadden, who was murdered by James Meehan, was informed by the Parole Commission that James Meehan would not be allowed out of jail. Now, who informed them? They were informed by the Probation Board in Northern Ireland. 2 months later, Meehan was let out on day release on his own. Who by? By the prison service. So how can we say the system works when a parole commission is saying we're not going to let this man out? The probation board care unit is saying he's not getting out, and then the police at the prison service let him out the door. That's what I'm talking about, cohesion. And then to double down on that, now that James Meehan has been out absconding from prison for a year, and he's up for his third hearing to be brought back to prison again. Nobody is attending those hearings to tell the family. So I'm literally getting questions from the family saying, I hear there was a hearing about James Meehan for his extradition. Nobody's come and told us what's happening. Could you help me out? And I'm literally having to do this. And do you know where they're getting the information from? Open source. They're not getting it from any of that list of information things that I've just given you. They're getting it from open source. In other words, a journalist is telling them. That's not good enough.
So look, as I've said, I appreciate that absence of information for victims' families can be incredibly distressing and so on. I don't really want to get into an individual case, but you mentioned pre-release testing, for example. Pre-release testing is there for a purpose. It's there to ensure rehabilitation. It's there to ensure that the system as a whole drives offending out of the system by helping to reduce reoffending once people are in our care. I totally accept that we can always get better and we will always learn from things that have not worked very successfully. And I'm very content, for example, in relation to victims and victim management systems. If there are improvements to be made, for example, with your proposal to cohere all these together into one big system across all of the individual agencies involved, I'm very happy that the criminal justice vision work would lead into something which does that. But again, the Criminal Justice Board, it's okay for me to say I think that should happen. We'll have to make sure that the Criminal Justice Board, which includes the prosecutor who has the information system, the victim support system there, it'll include the Commissioner Designate who's observer on the board, and it'll include things that the judiciary and that we as prison service do as well.
Yes, and I guess that's a fair point. And I'll be honest with you, I mentioned the McFadden family because they've given me permission to mention that, and that's why I mentioned it. And I have raised it on an awful lot of occasions, and this committee will know that I did it. But you did raise the issue of pre-release testing, and there is an argument that we're not adhering to the legislation in regards to pre-release testing. Who sets the criteria for pre-release testing? Who literally sets it? Where's it laid down that we can start pre-release testing 3 years before a life tariff actually comes to an end?
So pre-release testing is done under the responsibility of the prison service to prepare people for release. There's also the parole commissioners who need to be given information in order so that they can take a decision on whether people are fit for release or not. And that's the overarching framework in relation to why and how we do pre-release testing. It's then done, as you know, in a graduated way. So, for example, it's all part of the prisoner development model. People will work with the person in our care for the duration to help them get ready.
Sorry to speak over you. I know all of this. What you're just telling me, I know all of this. That's not the question I asked. The question I asked is who set that criteria 3 years out? Because if I look at the Life Sentences Northern Ireland Order 2001, it clearly states that the individual should complete the specified sentence which is required for retribution and deterrence. So if somebody's given 10 years life sentence, for example, he has to serve 10 years life sentence before he's considered, and therefore he should do that before he goes out the door. That's the retribution part of the sentence. So who has made the decision to allow the prison service to allow them 3 years before that tariff is ended to start pre-release testing? 3 years. So if we look at the Cowdery family and we look at McEntee, he was allowed out 30 months before his tariff was up. 30 months. And he was allowed out on his own. And the family weren't told. There's the fundamental problem that we have.
Again, I don't want to get into discussing individual cases. I'm quite happy that the process which has gone through in terms of pre-release testing is entirely consistent with the law. Where the 3 year figure is, I'm very happy to come back to the member on. I don't immediately have it on the top of my head as to which regulation or whatever puts that in place, but I'm really happy to come back and explain that. But I can assure you the entire process of detaining prisoners once a court has sent them to us, prison service is required to do that, making sure the sentence is properly served, and then when parole commissioner decisions are taken, making sure people are adequately released and prepared for the release in order to make sure that we reduce the chance of any kind of return to offending. In terms of where the 3 year rule comes from, I'm very happy to come back to the member.
Well, I don't think it's a 3 year rule. I think this is what the prison service have decided they do. They've said the three, and you were going to explain it, but I think we all know that the different phases before they are allowed to come out on their own. The point that I'm making is they're literally out before their tariff is up on their own on the streets before their tariff is up. So the judge sets a tariff, and it's quite clear in legislation that tariff is the retribution part. How can it be retribution if the guy's out the gate and wandering around the streets? So it's a fundamental issue, Hugh, and that's why I talk, when I said about the system isn't funny, it's the cohesion of the system, because one side doesn't know what the other's doing, and that's the point that I make. When the Paroles Commission is writing to a victim's family and saying, this guy's not getting out, and 2 months later, the prison service let him out on day release, that does not sound cohesive to me, and that's my concern. And it leads me, if I can, onto the Criminal Justice Board, which has never had a shared vision and has never had strategic priorities, ever. But the Paroles Board, Northern Ireland, don't sit on it. And the Paroles Senior Commissioner, doesn't sit on it either. So how do we get that cohesion in the issues that I've just raised if the very people that are responsible for some of this and informing victims, and I really do look at victims here more than I look at perpetrators, how are we supposed to get to somewhere where we can look at these issues?
Exactly through the process that we're engaged on, I suppose, would be my answer to that. So in terms of the parole commissioners not being on the board, the Criminal Justice Board, you'll know the existing membership. It's the Lady Chief, it's the Prosecutor, it's the Chief Constable, it's the Department. The Commissioner Designate now joins as an observer. There is entirely an argument that as we cohere around a particular vision, that composition may need to change, the governance around the board need to change, the bodies that report into it may need to change, its level of authority may need to change as well. We are very happy to explore that all with the CJB itself and the different participants, and then with the committee. In terms of very specifics as to whether parole commissioners or probation board or whatever should be on it, I think that'll flow from what's in the vision. But I agree, in terms of getting cohesion, I'm totally with you. The way you get cohesion as a system is to agree where the system is going and what it's ultimately trying to achieve. And if there is no, sorry.
No, go ahead. Sorry.
If there is no coherent vision, for example, in the health service, health of the community, free at the point of use, or whatever it is, similarly in the justice system, the criminal justice system, you will never get there, even with the best will in the world and really well-meaning organisations, which we all are. People won't quite know which direction to head in, or they won't know whether what they're planning is entirely aligned with what probation board are going to do next year and parole commissioner is going to do next year, etc. So I totally agree with that, and that's why the exercise we're engaged on and the thing that the inspector recommended is so critical in order to get right. And if that flows down through changes to how we deal with and keep victims informed of what's going on, I totally agree that would be an advance. But we need to get that core vision agreed and settled first.
And you're right, Hugh, because and we need to do it right. But we need to do it at pace, because victims suffer for as long as this isn't happening right. And when this cohesion isn't in there, and I don't think it is in there, Hugh, and it's not because there's not good people, because they are good people, but they're all pulling in slightly different directions. Because I could ask in this table here and say, what do we think a priority is here in Northern Ireland? And we'll all say violence against women and girls. That's what we'll say, violence against women and girls. We should be cohesive in violence against women and girls. Yet, for non-fatal strangulation, the PPS decides that they will send hundreds of cases to the magistrates' court and only 15 cases that goes to the Crown Court. Non-fatal strangulation, mostly against females. That's not really giving the message that we are talking about being strong on violence against women and girls. I know they're independent, but that's why I said this at the very start. I know they're independent. And then the courts give out some of the most pitiful sentences that I've seen. Now, we can argue pedantics here, but the people out there who want to have confidence in our justice system are seeing this and saying, well, everybody's saying that violence against women and girls is a priority, but the PPS thinks it's not, because they're sending perpetrators to the magistrates' court, not to the Crown Court. And if people look at the sentence you can get for going to the Crown Court, I think it's 12 years, and if you go to the magistrate, it's down to 2 years. Then people will see we're not really serious about that particular problem. Do you see where I'm coming from in that, Hugh?
I do, absolutely. And remember, very kindly pointed out, I'm not the PPS, not responsible for them. I would say from my engagement with PPS and talking to the director and so on, they are absolutely committed to the eradication of violence against women and girls in the same way every part of government is, and the TEO strategy in this regard is really critical for that. And forgive me, and the fact that a certain proportion of cases might be prosecuted in the magistrates' court and a certain proportion might be prosecuted in the Crown Court on any particular offence is always going to result out of the individual decisions which are taken by the prosecutor or the PSNI in each case and so on. So a lot of these are fact specific, but I absolutely take the point. If you think about the Criminal Justice Board, for example, and the member said they don't have priorities, they do at the moment have one specified priority, key priority, which they want everybody to focus on, and that's speeding up justice. And that will show benefits in all sorts of ways, including, it's not targeted at EVOG, but including, for example, in sex offence cases and in violence against women cases and in domestic and sexual abuse cases, because every day we can drive out, every day of unavoidable delay we can collectively drive out of the criminal justice system is a better day for victims, it's a better day for witnesses. And for example, in the last couple of years, I know the Crown Court still sticky, but we've got from 225 days down to 189 is in my head as the most recent report for the average median time for all cases. So we are getting there. We are showing progress, and the speeding up justice programme is intended to make more progress. And
I'm just hoping, Hugh, that the speeding up justice isn't why we're pushing cases that should go to the Crown Court to the Magistrates' Court, particularly on non-fatal strangulation, which is a crime against women and girls predominantly. Interestingly, there's one up soon, a man on man. It'll be interesting to see if that goes to a Crown Court or whether it goes to a Magistrates' Court. But I absolutely get what you're saying, but there is still a concern that people think speeding up justice means let's push them through the courts the quickest route possible. And that doesn't necessarily always meet the deterrent part of sentencing that we deserve. With indulgence, can I just ask one more question, please, Hugh? And this is a better, for me, understanding better. The Home Office are responsible for foreign offenders being deported if they get a sentence over 1 year. So if you're a foreign national and you get a sentence and it's over 1 year, then the Home Office are then responsible for deportation of that individual. But recently we had an individual who was up for withholding information on a murder case who got 2 years. But because of time served, the judge released him at the court, and there was nobody there to deport him. He just melted off back into society and then across the border, probably into the Irish Republic. Who's responsible for making sure that all the relevant people are there for cases like that? Do we know? The trigger point, in other words, who's the trigger?
I'm not sure I can answer all of that, but I will come to that for you. But could I just go back just to reassure everybody? So if there's any thought that the speeding up justice agenda, which is a very positive cross-system agenda to eradicate delay, is affecting prosecutorial decisions, I would imagine the DPP would say, well, it's not, in the sense of individual decisions. So the prosecutor has the prosecutorial test as to whether someone's prosecuted, and that is enshrined in law as the way that we prosecute people and the reasons we prosecute. Expedition or getting things done quickly is not part of that test. It doesn't mean that the programme as a whole isn't intended, for example, we're consulting on out-of-court disposals, and we'll be coming with proposals about the remit of the Magistrates' Court to allow the Magistrates' Court to take a certain level of cases that are currently in the Crown Court. Essentially the very least critical cases in the Crown Court might move to the magistrates. So initiatives like that, but they're all legal or administrative changes which would be well thought out and come in front, and none of those would affect the prosecutorial decision on whether somebody is prosecuted, just to reassure people about that. In relation to deportation, that is very much a Home Office function. I think the nubbier question was who's responsible if there's a possibility that somebody might be released time served, that there are suitable border force colleagues there ready to detain and so on. I don't immediately know the answer to that, but I'm really happy to come back. I take the point.
Trigger.
There will be some cases where people are in custody, then they're released and border force can take them immediately, etc. There'll be other cases where it's not immediately known that they're about to get out or whatever, because uncertainty about what the judge is about to decide. I don't quite know the answer to that, but I'm really happy to come back.
And that's fine, because of course there's a victim at the other end of this who watched this happen and nothing happened. And just before, sorry, Chair, just a very quick one. Could you please, Hugh, when you go away, have a look at domestic homicide reviews, and if the family waive the right for the victim to be named, so they're named, let's not give the perpetrator a pseudonym. I mean, let's change it. I mean, you can't have where the victim of a murder is named in a homicide and the guy who's doing 20 years in prison is given a false name. Can we just have a look and see if we can change that?
Very happy to take that away, Chair.
Thank you.
Okay, thank you.
Thank you, Chair.
Thanks very much, Chair, and Hugh, good to see you. Where I'm coming at is the issue of victims, and it has been mentioned multiple times here today, and there are some high-profile cases which we obviously can't get into here today because of they're before the courts, but I do know some of the victims very well, and it's the delay, and it'd be helpful if you could give us some of the department's insights into this. Just we'll take the three tiers: police, PPS, courts. And if you have any insights into, I know there may be some cases maybe slightly different to others, but have you any insights, or has the department done any work into why things are so delayed moving from police to PPS, and then seem to be spending quite an inordinate amount of time, especially around the Crown Courts?
No problem, Mr. McGlone. And I'm totally with you, and the Minister is totally here as well in terms of victims are at the core of this and making sure that victims are as looked after as possible. There has been an increasing length of time to dispose of cases, very slowly over time. There are all sorts of kind of reasons for that, which cause it. For example, complexity in evidence. We're now in a digital world that we weren't in 20 years ago, so you very often find that police have to analyse vast amounts of data, even on a relatively ordinary phone, etc. So there's all sorts of reasons why cases get more complex. But in terms of the interface, you mentioned the interface between PSNI, PPS and the courts. So it is recognised, for example, that when PSNI pass a file to the PPS for the PPS to take a decision, that could be improved. So for example, the quality of the information that's in that can always be improved. We have a project in relation to that. There's a thing called standard build, which we're trying to get introduced, which shows exactly what should be in each of those files. We're trying to do that as well. There's work being done on a pilot on no file decisions, so that actually the Public Prosecuting Service doesn't get involved at all. The decision is just taken at policing side, and that saves up PPS time. And then we've early engagement in terms of PPS and PSNI and defence practitioners and the perpetrator being involved in earlier discussions to see what we can't bring back. So we're calling that early engagement. So that even in that PSNI to PPS interface, totally accept that there are systems and that there are ways of working which can be improved, and the organisations accept this as well. And they're encapsulated, for example, in the Speeding Up Justice programme. So the Criminal Justice Board, by saying we are going to focus on, and our key priority for the moment is speeding up justice, led to some analysis by the department, albeit with information that everybody was giving us and quite happy to give us and quite happy to collaborate with, to identify those kind of 4 or 5 key hot spots where we think we can most get into delay. Largely, not exclusively, but largely kind of the interfaces between cases moving through the system. Beyond that, inside the organisations, there's work going on to improve things. So PPS has its own PPS 30 strategy, which is designed, for example, to make it faster and better at taking decisions. Through getting transformation funding in through the bid, we've been able to fund PPS, even though we don't normally fund PPS, but through that bid we've been able to get some money to them to allow for extra prosecutors to be taken on to grind through backlogs and to work with police then about things like case file builds and no file decisions. So there's a whole, in the Speeding Up Justice programme, I think we've briefed the committee. If we haven't, I'm very happy to come, but there's 5 big projects in that, and if you think of that one just as an example of that, we've 5 projects which are all intended to eradicate delay out of the system in that regard and make it better both for citizen, because things are delivered faster, both for taxpayer, because it ultimately is cheaper, but probably most importantly for victims, because they're left waiting less time for the ultimate disposal of their case and for justice to be done.
And then it's been mentioned already, and I think your phrase was to deliver justice at a pace and efficiently,
Yes.
you said earlier. There's a commonality, a common thread running through quite a bit of this stuff is communication. We've already heard some of it from different of the other agencies, where people, often victims, don't know what's happening and don't know why cases are taking so long. And that adds to the frustration and often the trauma that many of them are going through. What's your views at that? You dealt with 2 tiers there, the third tier. What about the third tier, the judiciary itself, or the courts, I should say, as opposed to the judiciary?
So I've no doubt whatsoever the criminal courts, the judges in them, but also the court service staff who support them and so on, and all the machinery around it, which also work, they're working as flat out as they can in order to grind. We have a backlog of cases since COVID, and they're working flat out to get through them. But the cases are really complicated. We still think that there are improvements in the way we could do it. So direct committal, for example, which the Assembly approved a number of years ago, yes. And the ministers recently said, look, we're aiming for this final cut-off date or final go-live date of November next year, is intended to help cases so that they don't have to go to the magistrate's court and be heard by a magistrate for committal before they go to the Crown Court. They can just be directly put into the Crown Court. It sounds nice and simple. It's quite a lot of moving parts to align with that, but there's an issue where the courts themselves will be able to be seized and to do more work. We're doing a project, or we're doing a bit of analysis with them about adjournments. So it feels to us that there are quite a lot of adjournments, for example, in Crown Court cases. We have approximately 13 adjournments per Crown Court case. England and Wales seem to have that at about 7 or 8, so we're interested in the reasons for that. A decision to adjourn has to be an independent judicial one, and we can't interfere with that. But if we can help the judiciary in some way, if there's more information we can do, if there's something about the flow of medical evidence or whatever it is, or we will do whatever we can in order to evaluate what's causing some of those extra adjournments and see if we can't reduce them. Because again, every adjournment as well as delay is cost, and it's not necessarily victims and witnesses would turn up for each one, but every time it drags on, there's more pressure for victims and witnesses. So there's quite a lot being done in that field as well.
Then the communications issue. which is pivotal to that for so many people. If they don't know what's going on, that doesn't mean that there isn't anything going on, but if people don't know, the presumption is that nothing's going on. And that communication strategy, I'm not sure how that's delivered. You'll know much better than I, because you're a legal person yourself as well. But that seems to be a significant deficiency in the system too.
So one of the things that I would anticipate might come out of the Criminal Justice Board agreeing a vision is then a communications plan in relation to it, which is not about individuals being told about their case, but it is about how the system works as a whole and what we're doing to try to improve it. In relation to keeping victims and witnesses informed, so PPS has a unit in it, again, part of the transformation that the system is, or the individual organisations and the system have been on over a while, is that PPS has developed this victims and I think it is victims and witnesses information unit within it, which keeps victims and witnesses informed about what's going on in particular cases. If there are individual deficiencies, don't want to discuss them here if you're content, but I'm very happy to pick up on them externally, whatever, and pass them on to PPS. And then the sorry.
Go ahead.
I was going to say that the last bit of it is it's communication with all of the stakeholders who deliver the system to make sure that they understand what we're doing and that they get, once the board has agreed this, we need all of the participants to come with us on that as well. And I would hope that there could be better communications, again, flowing out of the setting of the vision in relation to that.
Thanks for that, Hugh. And Chair, maybe if I could suggest, I know that in regard to some of the recent publicity around, the Lady Chief Justice has said she is content to come before the committee. But could I make the suggestion it would be helpful to have the PPS to talk about their pride, and also indeed the police to be here, and it would be helpful too, Chair, if you can be so presumptuous to say, useful to have them here all in the one day rather than those occasions where people tend to be tempted to pass the parcel a bit.
Okay, yeah.
If we could,
is that in light of the
suggestion
recent media interest in a certain case that's still live? Yep, okay, happy enough to. Well, happy enough to try and sort that out. As members agreed, I would assume. Yeah.
Agreed, yeah.
Okay.
Look at the broader issues, like not just that one. Yeah, sound.
Okay. Is that you finished, Patsy? Yeah.
Okay, thank you,
Morris.
Chair. Thanks, Hugh.
Thanks, Chair. Chair, I wanted to go back to the strategic recommendation and the operational recommendations 1 and 2, and it's just the wording. If you take the third the line from the bottom of the strategic, it says these should be clearly communicated. I would like to see the word must be clearly communicated. I'd like to see the word must in the operational recommendation 1, and the word must in the operational recommendation 2. Replace the words should. Should's an option. You should do it, but you might not. But if you must do it, you have to do it. And not only would I change the word from should to must, but in all 3 instances, I would have a strategic time frame of when that must take place. So, for instance, within 3 months, within 6 months, whatever is decided, there should be a definite period, and that would do away with the lack of communication. And a lot of instances that we've been talking about here today, and it'll give a lot of clarity. If the recommendations contain the word must and not should a get out clause.
It absolutely take the point, member, and completely agree. So the precise phrasing of this, it's the inspector's report, so I can't do anything about it. But I assure you, the department and all the CJOs, they take the recommendations of the SIGINI incredibly seriously. We either, as with any kind of external inspectorate or an internal audit, whatever it is, you do a bit of thinking about whether you accept the recommendation. But we have accepted all these recommendations, and therefore they become must for us. We have said yes, we accept the recommendation. So we're working through this. On the strategic recommendation, SIGINI's recommendation completely aligns with everything I've been saying that the Minister intends and that the CJB was, I feel, already kind of heading towards, which was setting a vision for the system as a whole. So what SIGINI has recommended is entirely alignment with what we think about how a different approach to the way the system works can help get better outcomes. And then on the 2 other ones, so we've already actioned those. It was Mr. Kingston earlier asking me. So just to reassure you, we have gone to, we've gone out to the organisation specifically. The first operational recommendation is PSNI. They have treated it as a must. They have looked at that. And then the second one is for the whole family, and we've gone out to everybody, and everybody is coming back to us And if we get something anything further than that, as I was saying to Mr. Kingston, I'm really happy to bring that back. But to reassure, and Sejini does a lot of reports, quite rightly. Everybody values what they do. There's one out today, I think, on PPS. PPS, I'm sure, value what is in that. In the same way, the Audit Office do reports. In the same way, His Majesty's Inspector do reports. In the same way, our own internal audit people do it. We take those all incredibly seriously, and even if the language is you should do this, as long as we accept it as a recommendation and we agree it's a good thing to do, we treat it effectively as a must. So I hope,
very much
that's
that. Just one
reassuring
wee
for the
brief
member.
one, Chair, with your indulgence, and that is that when you're rolling out the recommendations, can you produce a strategic time frame of when they should actually take place?
Again, so one of the ways that we would treat these and all other similar reports and so on, we'll actually respond and we say this is what we'll do in response to it. So there is our response to this, which goes to Sejini and so on, or when internal audit report on us or audit office report on us, we'll say, right, we accept this recommendation and we'll do the following things in relation to it. And very often there'll be a time in that. Sejini have said, for example, we should have the vision work complete within 6 months, but that was not possible. I've gone over already the number of moving parts and the number of people we would need to discuss in order to get it into place. But we've spoken to Sejini about that, and they understand that actually it would take us more than 6 months. But I assure you then when we get from the vision to a work plan, as I was saying to Ms. Hargy earlier, there'll be a detailed work plan which, for example, over a 5-year period, will begin to set out exactly what will happen when on each of the individual strands of work in it. In the same way, for example, in the Speeding Up Justice one, we can show we're working towards committal reform, direct committal on November 2026, and here's several steps before that which must happen to make it work, and we've got a date for all of these things lined up in a plan, and everybody knows who's doing what when in order to deliver it. So
Okay,
I hope that's reassuring for the member.
Okay. Thank you, Hugh. Just a general fashion, I'm obviously keen once the vision is agreed and there is a work plan. Have you a timeline in relation to when you want to develop a work plan? And that will obviously impact then operationally and when we're going to see a change. And likewise, just on that bigger picture, is what tools are you going to utilise to be able to build that cohesion across our CJOs? Are you considering like ring fencing your budgets, for instance? But you're going to need tools because it is quite difficult, as we know. All our agencies are flat out. There's huge delays, there's huge backlogs, there's huge staffing issues. So I'm just conscious of it's great having a vision and a work plan, but you're going to need a bag of tools to be able to bring on the workforce across the CJOs in under this vision. You know, so I'm just. Is there any thoughts at this stage how you deliver on it?
Really helpful, and thank you so much for the vote of support that I can deliver on it. So when we go to CJB in early December, we'll be saying to them, this is what we propose to do next steps. Can you agree, for example, that we'll do this work plan? I would anticipate that they would, but I can't promise that or whatever. But that will include some proposals about timing. There's no point in hanging around once they've done it. But again, if you think about a work plan for the next 5 years for something as complicated as the criminal justice system, it would take us a while to develop it. In the same way we agree we're going to transform health, it takes us a while to agree what that actually means in terms of interventions, but we'll do that with pace as much as we can. The Minister is absolutely adamant about it, that we want to move fast on all of these things because, frankly, the budget settlement for the executive next year from UK Gov and other sources is going to be so tight and so difficult for everybody that there's no point in waiting around if there are things that you can do in order to make things better and to be able to do things more efficiently. And that'll affect all departments. That's not specific to us, and it's not a plea from the Department of Justice for a better outcome from the budget or anything. In terms of the tools, you might anticipate, for example, that if we've agreed we're heading towards this, we have a digital strategy under development. So on the basis that a theme in the emerging vision might be around efficiently running the system at pace and effectively and efficiently, you could see that digital would have a major place in that. So I would anticipate things like the digital strategy, which, to be fair, are for the justice system as a whole, but would have a criminal justice kind of element within it, could be used as a tool in order to try and deliver those things promptly and efficiently. You might envisage funding tools, but those would be difficult and those would have to be agreed with everybody. So you might say, for example, in terms of the capital spend, you might say, well, the capital spend must necessarily align with the vision and the work plan. But again, the organisations would have to agree to that and might even agree some kind of criteria about how you would spend capital money over the next while. But that's really difficult because, for example, the PPS it gets its own vote of money from the Assembly. We're not in control of that in any way. The PPS director is the accounting officer to the Assembly. But again, if we got everybody to agree, if this is our vision and these are our core objectives, this is what we want the system to be like in 5 years' time, that means we need, for example, more investment in Causeway, or we should be focusing on Thamus, or we should be focusing on an individual kind of identifier for each person in the criminal justice system, totally anonymised, but it just speeds up the tracking. Then things like that, you might collectively agree those are where we would focus. So you might see things like capital spend. It's not quite ring fencing, but you might see it put into that. And I suppose the last one was we will keep on bidding for further transformation money, because this, be under no illusions, this would be a transformative step for the criminal justice system. So on the assumption that the transformation fund to some degree would continue in existence, as I said, we were quite successful on the speeding up justice bit. Our bids in at the moment include violence against women and girls. They include digital capacity within PSNI. Because of the vast amount of information, it frequently needs to pass over to things like inquiries or tribunals or individual cases or whatever, so to make them slicker in terms of, even slicker I should say, or to have a system across the digital evidence and information system across the justice system as a whole. All of those things would be kind of routes and tools that I could see. Whether we can get all the organisations to agree will be for working out the work plan, but I could see those absolutely working as tools to get this to a positive conclusion.
I think that's really pertinent. Organisations need to be incentivised, they need to be able to see the bigger picture, and that builds trust, building the trust and relationship across the departments where they can see the bigger picture, and everyone can benefit. It's critically important. Just two other aspects you mentioned, obviously the violence against women, and I know this is about cohesion across the criminal justice organisations, but how effective or how well do you think the department is in coordinating across departments, particularly in the delivery of violence against women, to create that unified approach across departments on it at this moment in time? And
you'd expect me to say I think the department is great at it, but in terms of the EVOG strategy, so that's TEO, and it's been developed across the executive and all the partners as a whole, but they kind of monitor and watch over those bits, but we have our role to play in that. In terms of the justice system, I suppose, and our partners around it, I think it's fair to say the department has driven that quite well, and the Minister has championed it very persuasively, but there's nobody in the system who hasn't picked up on it. So the Policing Board are completely behind it, the Chief Constable, PSNI completely behind it. The PSNI have their own campaign, Power to Change. We've enhanced the criminal justice law book by putting in all sorts of further offences. Non-fatal strangulation was mentioned. We're coming with proposals about deep fake imagery and so on. So we are pushing issues like that as well, and where we can across our part of the whole executive system, but also where it interfaces with others around us, like homelessness issues with housing executive or partners around in mental health and so in terms of getting out of prison to reduce offending. In this case in particular against women and girls, we're absolutely pushing everything we can in relation to that.
just one final one, and just declare an interest that I am Vice Chair of the Access to Justice. But just on access to justice, and in particular, it would be remiss of me not to mention obviously the issue of legal aid. And where is that at? Because obviously it seems to be a moving feast in relation to the business case, and the Minister has gave assurances that the legal aid will be uplifted. Can you provide any clarity or any specific timeline on when this uplift will be introduced?
Forgive me, maybe you have colleagues from Enabling Access to
Taxation
Justice
next,
coming in
yeah.
after me who might be able to give you a more precise answer. It has been delayed a little bit more than we would want it to be, but partly because some of the proposals which have come from the system or stakeholders into us just need a bit more working through. So some ideas have been brought in lately about for things like skeleton arguments and so on. So we're trying to make sure that those things are all mapped up, and you'll be aware Criminal Bar Association are kind of deeply engaged in terms of trying to persuade the department that there should be kind of particular outcomes of what the result would be, and then every time that changes, necessarily the business case must change as well. I would defer to Steven as to when, forgive me, my colleague who's coming in after, just to defer as to exactly what the latest is and the timeline of that. But I will say the department has been working incredibly hard with it, and we meet the bar and we meet the Law Society and we meet other stakeholders in this very regularly in order to try and push this to a final conclusion and get the business case done, so that we can therefore get the uplift of the fees in place. And just to reassure everybody, the Minister's already agreed that that'll be backdated. I forget the date off the top of my head, but it was to the date when she took the decision, even if it takes us longer to get both the business case done and then the necessary legislation prepared and through the House.
Just one wee final one, just as a department itself, because I'm conscious when I am out and about, have you done any modelling up of the negative impact that this ongoing issue has been having in relation to, particularly in our local towns and our rural areas, and accessibility to local solicitors who in the past focused in on legal aid and are maybe walking away from it at this moment in time? Is there be any thoughts on that, or where that what the impact has been over the past year and a half?
Forgive me about the withdrawal.
Yeah.
The amount of so I think it shouldn't be affecting local solicitors too much. Again, I'm happy to be corrected about that, but we're really conscious in particular about the impact on victims. So a victim's case is being delayed because of this, and that's a matter of real concern to us. And witnesses maybe anticipated being called by a certain date and then aren't, or are told you can't come on that date, we need you to come on some future date, and so on. And no amount of positive engagement from PPS will secure all witnesses to a place where actually they may be willing to come back in 6 months' time. So if a case is delayed because of the withdrawal, then actually there's a risk that ultimately justice may not be done in that case, or at least the issues can't be fully thrashed out. And I suppose that the victim has to wait even longer for justice. And the Minister's been very clear about this, that the damage and the harm done to victims is of such importance and such magnitude that it simply doesn't justify any withdrawal of service. And we encourage all the parties in this, and the bar in particular, to come and continue to engage with us. They do that. There was this recent issue a couple of weeks ago where we were speaking to the Bar Council, and then a few days later the CBA indicated they might do something in particular, but we think we're on a better path in relation to that now collectively. So we are really conscious of it. In terms of the overall impact of the business case, then yes, I would anticipate we'll know what that means for at least solicitor income, whether solicitors can then translate that into, yes, that means we can continue to exist or whatever, is a slightly different issue. But we do work with the Law Society very regularly on that. And one of the Law Society's submissions into us, when we were trying to decide what the correct level of fees is, it was about, well, this is kind of the core cost of a solicitor's business, and this is how much they need, and you need a certain amount of profit, perfectly reasonable on top of that, etc. So broadly speaking, we think the fees should be in this kind of region. So that was all taken into consideration in Tom Burgess's original report, and we continue to work with both the Bar and the Law Society in relation to all of those issues.
Just to reiterate, it's such a pressing issue, and I would have grave concerns of, obviously it boils down to access to justice, but those withdrawn services and not providing even legal aid cases. So it's just, that would be a grave concern, which obviously has an impact then on victims who don't have access to a service. So how pertinent it is to get it resolved as soon as possible. But thank you.
I'll take you back to the original basics. The Sagini report, published in November 2024. It gave you 6 months from the publication of that report for the DOJ should facilitate Criminal Justice Board members' agreement on a shared future vision and strategic priorities to deliver transformational change and innovation across the criminal justice system. When was the first time the Criminal Justice Board spoke and discussed this?
That's an interesting question, Chair. Forgive me. I'm not sure I would know, but I would anticipate it was the meeting. So the report would have been brought to the Criminal Justice Board. I can only anticipate after the first meeting. I'm really happy to check that and bring it back to you, but I would have thought that's the answer, is that it was at their first meeting after, and it meets roughly speaking 4 times a year.
So a letter here we've got in our pack. Initial work was commenced within the department and was discussed at the Criminal Justice Board at their meeting on the 27th of March. Would that have been the first time?
Yes.
An engagement plan then was subsequently developed and agreed at their meeting on the 30th of June, some nearly 8 months since the published report, yet Sagini gave you 6 months to facilitate it.
Yes, and I totally accept, I was trying to answer Mr. Bradley as well, I totally accept Sagini have said go and develop a vision and do it within 6 months, but in terms of the complexity of the system, in terms of the number of partners that we have, in terms of the operational independence, realistically speaking, I don't think that you could actually successfully deliver one. You could impose one or seek to impose one, but as I was trying to indicate earlier, in terms of the operational independence of all the partners in the system, our assessment, my assessment personally, I think the Minister's as well, is that the only way to make it successful for the long term is to make sure that everybody's built in at the construction stage and that everybody has their voice in relation to that. So that meant necessarily going and having detailed discussions with PSNI, going and having detailed discussions with PPS. As I mentioned, we brought in an independent facilitator to help with that, so it didn't feel as though DOJ was just telling everybody what the answer is. And all of the other people I've mentioned, I'm happy to repeat the list, but I've mentioned the list of people that were spoken to in relation to. So that, doing some preliminary thinking, having those conversations, letting the people we talk to, like the Chief, like the Lady Chief Justice, come up with their own thinking about it, feeding that back in, translating it into something. Realistically speaking, I doubt that's something that I could do properly, or that I could assure the committee was done properly within 6 months. We did speak to Sagini about that, and we said to Sagini, look, we're embarking on this now, what do you think? And we haven't had any pushback from the inspectorate about taking a little bit longer to do it. I'd love to get things done much faster. I'd always love to get things done much faster, but in a complicated system of many parts, trying to tell it to operate in a particular way, it wouldn't be, in my assessment, the kind of most successful way to go about it.
We're talking about transforming the system. We're talking about the speeding up of justice within that. Where do you demonstrate the urgency?
Well, I think we demonstrate the urgency by the fact that we and others are continually transforming the system and have been for the 15 years since policing and justice was devolved. So nobody has sat around since policing and justice was devolved and waited until this moment to come up with change. Everybody's already been at considerable amounts of change. I think we talk about it less in the justice sector than we do in other places. Or maybe we kind of subdivide it a bit and we accept, yes, PSNI is a transformed organisation in the last 15 years. Youth justice is quite different. Probation, the way they do their work, is quite different. Things like ecos, things like diversion, things like restorative justice. I think we talk less about those as coherent transformation across the justice system as a whole. But I think it has been there, and I think that shows that everybody continues to do it on a regular basis. Pace, absolutely. Pace is driven, and there's none of these organisations which, once they've decided they want to change something, sit around and don't do it without pace. Sometimes it can't be properly funded, and it has to wait, because there simply is not enough money at the moment to do all of the things that we want to do to improve the system. But I do think people, once they embark on these, will do it. Ecos, for example, so you'll know we've rolled out Ecos, enhanced combination orders, as an alternative essentially to short sentences and other issues, to get a better impact on the reoffending rate. And they have been pushed very successfully by probation board and by judicial colleagues to make a great success. We've rolled them out where we can as we have the money. We've bid, one of our bids into the transformation fund is for more money to yet Ecos roll out further, because we can see the benefit that they do. So it's not that we and probation board colleagues aren't driving that forward with pace. It's that we can't always secure and carve out the necessary funding in order to deliver it at this moment, but it doesn't mean that we don't want to do it.
Do you accept that the fact that there was no vision in the first place is abject failure?
I don't accept that, Chair. I think for a system which is composed of the individual parts who all have their own objectives, not to have a common vision, that's not unheard of. I think for them to agree, despite all of their independence, that they want to have that and that they're willing to engage on the discussion to have it, I think is. I don't think I would describe that as failure in any way. I think that's quite a positive thing, and I think the Lady Chief Justice, and I think the Chief Constable, and I think the Prosecutor, and I think ourselves and the Director of Court Service, I think have lent into that as much as they can in order to make that a success.
What is the Department of Justice's vision
Our vision is, well, we have a mission. So the mission for the department is working together for fairness, justice and safety. So that's the core mission that the department has. The Minister has set us some priorities for the next period. So there are things like reducing offending, there are things like looking after victims, there are things like community safety, there are things like empowering people, because we recognise we have to invest in those in the department in order to help drive all that change elsewhere. So those are the core things that the Minister has set out that she wants us to prioritise for the next period, and those together with our mission effectively combined to make the vision of the department. But that's the department servicing everything the department services, including civil justice, family justice, tribunals, firearms, explosives, all of the stuff that we do, which isn't really in the criminal justice system as a whole. I think it's reasonable to say that with all the moving parts and the independence in the criminal justice system, getting it to formulate a vision itself, which means collectively around the leaders that I've just discussed and the organisations we've been talking about, I think it'll be most successful if that vision is created in that system, as opposed to imposed by, for example, me saying, well, I think it should be whatever.
I would argue the difference between a vision and a mission is that the vision sees in the future what you want the department to be. What do you want the department to be?
So separating myself from the Minister, I would like the department to be as efficient as we possibly can and as effective as we possibly can in delivering what the Minister asks us to deliver and what the programme for government and the executive want us to deliver, and better outcomes for our citizens. And they're all measured, and they're capable of being measured through the programme for government machinery. But for him, that's me. And I will do it with probity and value for money and make sure I can account to the PAC in relation to that as well. So all of those, that's what I would like the department to be. But ultimately, all the policy questions of what it is that the department should be doing in terms of, for example, changing the law or what should be a criminal offence or not, ultimately that we get ministerial direction on that. Currently, that's coming from my current Minister. I want the department to be fit to serve the Minister that it has and whatever Minister we may have in the future, in the same way the civil service is trying to be fit to serve the executive of today and the executive of tomorrow.
You're all very high level. Have you a time scale for all that high level?
On an ongoing basis, in terms of helping the department improve, I think the department is already great. Actually, I think one of the first things I said on coming in to the committee last year was that the Department of Justice has this incredible reputation already. When I came into the department and was able to look at it a bit from the inside, as opposed to just kind of partnering it over the years as its legal advisor, that was even more obvious to me. But just seeing the quality of the people around it, and that's the department and the system. I hope that I've helped in the last year to get some coherence, for example, around this issue and issues like this. I hope I'm persuading the committee that we're here to work with the committee and we're here to work with the Assembly in terms of delivering this. My agenda is, if you ask me about timescale, Chair, my timescale agenda is always about pace. But it's realistic pace, it's pace with quality, it's pace within what's affordable, it's pace without doing damage to things that are also important, as well as doing things promptly. And I, again, with the committee's support and maybe with some support from the Assembly in terms of diverting a little bit more funding towards the justice system so it can make this improvements, I commit to the committee, I'll drive that as much as I can inside the system, as much as I can in the time available to me.
Okay, Deirdre wants to come in, and I think
It was just a
very
quick
briefly,
one,
please.
but an important one on finances. So obviously the new legacy bill's going through Westminster at the moment. There's obviously 9 outstanding inquests. There is to be a new legacy commission and information recovery body, and then there's also 2 public inquiries which are looking at and the big issue of resourcing, even PSNI resourcing to service all of that as well. And we know with the OMA inquiry at the moment, other information is being put on hold to allow the PSNI just to even service that one. So it's just to see either you can write back to us or if there's a quicker answer now, Hugh, just on the views of the department in terms of resourcing around all of this. And has there been any engagement with the British Secretary of State or with the government more directly?
I'm really happy to give a brief answer now and to come back with some more. We got a copy of the bill on the same day it was introduced into Parliament. The Minister has been very clear throughout that there are legacy costs which are very substantial, and some of these do not really fall for the executive to meet, let alone the Department of Justice or partners like the PPS, etc. They fall for UK Government, the Minister has been very clear, and indeed I think other executive partners have been clear about that as well. OMA, for example, I think from recollection it's something like 2.5 million that the PSNI I think they need just to service their giving of information to the OMA bomb inquiry, which is quite right, they should do that. Statutory inquiry becomes a statutory duty to respond to it. But where is the 2.5 million going to come from? So I think there is an argument there, and I know the Minister has put the argument, and the Finance Minister has also put the argument to HMT, Treasury, in relation to making sure that these things are properly funded. You'll have seen the Chief Constable is identifying that there's an increasing cost of civil claims in the legacy space as well, and the argument I think inevitably was going to be that is an ongoing pressure, regardless of exactly what the quantum of it is, and I think the Chief and indeed the Minister would say that is a scale which was not anticipated in 2010, and therefore I think there's something which must be taken to UK Gulf. But I'm really happy to come back with a bit more detail about the costs of particular elements of that as we
Yeah,
go.
no, it'd be great because I would concur. It shouldn't come out of the block grant for the reasons that you've outlined. Thank you. Thanks, Chair.
Forgive me, just to supplement that, I suppose in the new legacy body arrangements itself necessarily cause cost for devolved organisations. Just to be totally clear about that. So if we have to do more inquests, or if we have to put more information, we collectively, like us or PSNI or PPS or somebody, has to put more information into an enhanced inquisitorial process or whatever it's to be called with the new body, that's got a cost to it. The argument is that that cost derives from the fact that it's UK legislation, not from anything that the executive has come up with, and therefore that a case should be made or could be made to UK Gov to fund that. But we work very closely with DOF colleagues, as you know, on all these things. And the way to approach Treasury is not individual departments writing off, or individual ministers writing off to the Chief Secretary of the Treasury or whatever. It's work with the Department of Finance. They've got this ongoing series of issues which they discuss with Treasury all the time in order to get the best possible settlement for Northern Ireland.
Thank you.
Okay, Doug, you want a quick?
Yeah, very quick one, Hugh, and you might want to come back on this one as well, so I'm not asking an answer now, but the Policing Board review reported back in the 30th of January this year. It was quite critical of DOJ, describing the tripartite arrangements as a two-legged stool and a parent-child relationship. When are we likely to see some of the outcomes of that review? When are we going to start action in that?
I don't immediately have that with me, but I'm really happy to come back to the members, to the committee as soon as we can.
Good enough.
Okay, that just remains then for me to say thank you very much, Hugh, for your time here today. It's been a marathon session. As you would expect, being the Permanent Secretary, you're getting hit with all sorts of issues and areas. So again, thank you very much for your time, and I personally look forward to working with you in this relationship to try and enhance things and make things better. So
thank you, Chair. How nice to see you, and thank you, committee. I hope the committee found that useful. I'm really happy to do it anytime.
Thank you very much. Thank you. Okay, can I then advise members that the Minister of Justice last appeared before the committee on the 13th of March. Could I seek members' agreement to invite the Minister to provide an update on the work of the Department and key priorities at the earliest opportunity after the Christmas recess? Members agreed?
Agreed.
Maybe members would be mindful just to highlight any issues that they may wish to discuss with the Minister during that session. It doesn't need to be displayed or aired today, but you can get that to the staff. That would be helpful. Agenda item number 5 then is Enabling Access to Justice Reform Programme and Taxation Reform Update, Department of Justice Oral Evidence. And I refer members to pages 216 to 297 of the meeting pack for the relevant papers. Can I inform members that today the committee is receiving oral evidence from Department of Justice officials on the Enabling Access to Justice Reform Programme and Taxation Reform. The witnesses providing evidence today are Steven Allison, Director of Enabling Access to Justice Division, John Bradley, Legal Aid Reform Branch, Enabling Access to Justice Division, and Chris Barry, Taxation Reform Branch, Enabling Access to Justice Division. I just welcome the witnesses to the meeting. Stephen, Chris and John, you're very welcome here to the committee, and can I invite you then to make an opening statement? Thank you.
Thank you, Chair. Thank you, committee members, and thank you for the opportunity to attend today to provide an update on the Enabling Access to Justice Reform Programme and the planned approach to taxation reform. I'm conscious of your time, so I'll endeavour to try and keep my opening remarks brief. I hope the papers provided in advance of today have been helpful. As you're aware, we undertook a public consultation on the sequencing and the priorities set out in the delivery plan that was announced last December. I'm grateful to everyone who provided a response to that consultation. Those responses have been carefully considered and have informed the development of a revised delivery plan. And as I noted in the papers, we're just waiting for the final part of the jigsaw, which is Judge Burgess and the working group report coming through at the end of the month to inject whatever's been agreed through that working group into the plan, and then we will share it with committee as soon as that's been developed. As we note in the briefing pack, the scope of the reform programme remains largely unchanged. Sequencing has been altered. We recognise that it covers a wide spectrum of areas, but essentially these fall under 4 main work streams, namely legal aid reform, covering remuneration and the wider structural reform, taxation reform, enhancing support for citizens, and developing alternative dispute resolutions outside of the court arena. Turning to each of these briefly, on legal aid, there is and has been considerable focus on the ongoing reform of legal aid remuneration, with significant time and resource being invested through the working group established in March under the chair of Judge Burgess to progress further changes to legal aid fees within the criminal legal aid sphere. And we want to progress any further legal aid fees beyond the raft of amendments fall under what is collectively described as the 16% uplift that's been collectively pulled together. Although those uplifts have not been implemented as quickly as we had planned, the uplifts are now being delivered in line with the timetable set out by the Minister at her recent meeting on the 5th of November with the Law Society and Bar Council representatives. The new fees and payment of the backdated fees are anticipated to be available from early January. Just to give the committee some sense of scale in terms of the backdated payments, at the end of October there was approximately £4.6 million of backdated payments in the system ready to be issued automatically once the enabling legislation comes into play in the new year. Significant progress has also been made on further amendments to fees on the criminal space, specifically on PACE fees. We are working with the Solicitors Criminal Bar Association to develop and implement a pilot as soon as possible in early 2026 on PACE. We're also making progress with the SCBA on the development of a pilot to streamline some process and underpinning fees within the Magistrates Court arena. Again, the aim is to implement that pilot early in 2026. Less progress has been made with the Criminal Bar Association. The main focus from April has been on development of a refresher fee pilot. We issued proposals in relation to the pilot to all stakeholders in early August, which would see a significant increase in the level of refresher fees in excess of the 25% recommended by Judge Burgess in his August 24 report. The pilot proposals have broad support from all stakeholders with the exception of the Criminal Bar Association at this time. But it is important for me to highlight representatives of the former Criminal Bar Association. As you know, they resigned a week or so ago. But the former committee invested significant time alongside Judge Burgess, myself and my team to progress those matters. But given that we have a mechanism in place under the chair of Judge Burgess, i.e. the working group, coupled with the fact that the Bar described the meeting with the Minister on the 5th of November as positive, constructive and reassuring, and I know the Bar Council representatives relayed that to the CBA members at their EGM on the 7th of November, it was disappointing and deeply concerning that a number of CBA members had to be persuaded by the Bar Council over that weekend not to withdraw from all Crown Court cases with immediate effect. We remain committed to engage through the working group with all parties to progress further reform of legal aid fees. Judge Burgess remains committed to deliver an agreed roadmap / action plan to progress reform, with that report due by the end of this month. And I'm confident in the discussions we've had with the Bar Council and the SCBA and Law Society that there is still remaining a commitment. I haven't met yet with the representatives of the CBA. I hope to do that in coming days. We'll see if we can take forward and pick up from where we left off on the 5th of November. On wider legal aid reform, written briefing on the current policy options under consideration will be provided to the committee for your consideration at next week's meeting. But John and I will be happy to answer any immediate questions the committee may have on that today. On taxation reform, we have set out in the briefing pack the rationale for the revised approach to taxation reform and how we propose to take that work forward. And again, Chris and I will expand on that further today if helpful. With regards to the enhanced support for vulnerable groups, we are developing proposals within the planned structural reform of legal aid to make it simpler for victims of domestic abuse to access legal aid, and also to introduce safeguards to reduce the opportunity for individuals to weaponise legal aid to induce more stress and trauma on victims. Again, if helpful, we can expand on that further today. And finally, looking beyond legal aid and taxation, we are working with key stakeholders such as the Ulster University, the Law Society and other sectoral organisations to develop alternative dispute resolutions for citizens. For example, we're developing options for a mediation pilot, or indeed pilots, with a number of those groups, and we're currently working with the Ulster University to introduce an online dispute resolution pilot in early 2026 relating to small money damages cases. Chair, I did promise to keep my remarks brief, so I will close at this point to take questions.
Okay, thank you very much, Stephen, for that. I'll put it out to members then straight away. And Doug Beattie.
Very brief, Stephen. Thank you for that. A lot of this is complex, and I fully understand this. I'm just going to ask you a quick question on the peripheries of what you were telling us about. Legal aid tables. We used to have them, and then we were told by the Justice Minister we're going to get legal aid tables back again, so we understand what firms are being paid from the legal aid budget, which is quite substantial here in Northern Ireland, but more importantly, what the case is, so we can have a better transparency and understanding that we're spending a lot of legal aid on legacy and historical cases, or the contemporary cases, or is there any word on that? And just to finish it off, to save me having to ask two questions, could you give us an update on where we are on fraud and error as well? This is a question I kind of ask all the time.
Probably start the reverse those on fraud and error. Doug, to be honest, I'm not the best person. Paul Andrews would have all of the details on fraud and error as the Chief Executive, so I wouldn't have those immediate available to me, but right. I can speak to Paul after this and get something to the committee. Okay, it's just because I don't think they've been released for this year yet, have they? I'm not aware.
The figures were for last year, but they haven't been released for this year yet. I'm just trying to see if we're going the same trajectory, and that is we're improving and cutting down on fraud and error, and to understand whether or not the accounts have been qualified again this year, because as they have been qualified every year since our legal aid. So that's all I'm after, just to understand we're going in the right direction.
I'll ask, to say I would be stretching into space there, and Paul will probably have my legs for it. So, on the former, again, it is more a matter for the Legal Services Agency, but the Minister remains committed to publish the details. We do have 2 ongoing cases before the courts challenging the release of information, so until we get clarity from the courts in terms of the outcome of those judgments, we just have to wait. That it'd be inappropriate for us to move forward in that. So there is personal data, there is information there that people can do a jigsaw and so forth to find out who's involved in what, and issues attached to that. So again, the Minister's committed and wants to release information, transparency. I have some figures, for example, I can give today in terms of criminal legal aid, in terms of distribution of legal aid and levels of payment. But not by firm. I wouldn't.
No, and that's fine. And to be honest with you, Stephen, and thank you for that. It's just making sure that that's the direction we're going in. Of course, if there's court cases there, we have to wait for the outcome of that. Yeah. But if those court cases are resolved positively, if the Minister's still then going that direction, there shouldn't be any other impediment then for that to be the case.
There should. Again, it will be up to individuals on the case, and when we're doing that, there will be a process for Paul to inform individuals and companies when something's going to be published. They might take decisions that take it into a different room, but the principle of transparent publication of details on the spend of legal aid, the distribution of legal aid, it's the Minister's full square behind that.
Thank you, Stephen. That was short.
Okay, Patsy.
Yeah, thanks very much. You mentioned a figure there of 4.6 million of back pay, or arrears, we'd call it that. What period of time does that stretch over, and how many hours does that involve?
I don't have the hours, but there's a number of dates that speaks to. So the vast majority of the dates go back to backdating goes to the 1st of December, which applies to the 16% and all of the recommendations that flowed from Judge Burgess' report that we accepted. There are a number of
1st of December
2024.
2024.
Yep.
Okay.
The next date that we move to is, I think, the 8th of April, when we had agreement from the Minister on changes to fees for immigration and asylum cases. So
The principle being once it was agreed, we backdate it to that point. And then there was a number of fee changes made to PACE and parole that I worked through with my colleagues with the SCBA from January through to the end of March. We have backdated those to the 15th of May. So there's 3 dates there, Mr McGlone, that relate to the backdated. That 4.6 encompasses all of that, and the 4.6 also includes all civil, family and criminal fees that were uplifted. So it's not...
It would be helpful if how many hours that covered. I presume that's the basis on which you calculated, is it?
It won't necessarily, Mr McGlone, because particularly with the criminal fees, they're standard fees.
Right, okay.
So there's no time in line assessment. It's based on...
I take it some of them will be hours and then some of them will be just amounts due. But how do you calculate it?
Well, it's based on the bills that have already been submitted.
Yes.
And then the LAM system, the management system, the payment system has been amended to automatically update.
So no, I get that. But presumably some of those bills will be for hours and some of those bills will be for service rendered. We'll call it that.
There'll be a combination of composite fees, standard fees, time and line fees.
It'll be helpful. I know if we had that, then we get a better indication as to how it's going and where it's going.
I think it'd be possible for us to give you a breakdown in terms of, it might just be a broad breakdown in terms of family, civil, and get it to as granular level as possible, and I'll have a chat with Paul.
Probably whoever's paying it and calculating it would need to know, wouldn't
they? I mean, I know Paul has this at the touch of a button in terms of 4 point. You can give me each week what the figure is. So yeah, I'm more than happy, Mr McGlone, that we can...
Thank you for that. Now, can I come to the taxation of legal costs? Just explain to me the thinking around that, because the concept as I have it is that there is a body independent that is determining those fees. So explain to me just the rationale of trying to bring that into the control of the department.
What we're proposing bringing under the control of the department is setting the level of the RD rate for solicitors and setting a rate for barristers in terms of hopefully an RD rate. What we're not bringing into the department is the assessment role that the taxing master currently has, which is to look at the bills, the brief fees, whatever submitted, based on RD rates, based on a brief fee basis, and determine if they are appropriate for the work done. We're not changing that. We are proposing keeping the taxing master and the independence and the value that he brings to that role. But for accountancy principles, transparency, and predictability of the budget, it's important for the department to be able to come before this committee and the Assembly to say, this will cost this amount of money. We're setting a rate of X for an RD rate for solicitors. It'll be reviewed each year, each 2 years, whatever, similar with for the barristers. So the only thing we're bringing under our control is setting the rate. What we're not doing is looking at the hours and assessing the hours that someone works. That'll be a matter for the taxing master to say, £155 an hour is the hourly rate struck at the moment. 155 times 100 hours equals what?
What would the point of them then?
The taxing master.
What would be the point of them, the taxing master or her?
I think the value the taxing master provides in this role is he's best placed to decide whether the hours that have been claimed are appropriate for the work done. It's looking at a bill and saying someone's asking for £100 hours at X pounds an hour. The taxing master at the moment will be looking at some of those bills and saying I'm not content.
Sorry, I'm not being confused by this. This seems to be from streamlining something into making it more complex, to my mind anyway. So if you have an independent arbitration body, or whatever it is, that independently arbitrates upon, and I presume you're not for a minute suggesting that the taxing master has been overly generous to legal colleagues or anything like that. I presume not.
Definitely not. I'm not making any comment on the taxing master.
If it ain't broke, why fix it?
There's two elements. I mean, from an accountability point of view, and there's a PAC recommendation that the department look at this and look about bringing the expenditure under the purview of the accounting officer. But the system as it operates at the minute is council submit a brief fee for the vast majority of the work that they do in the High Court and the Court of Appeal. That's one line on a bill. It's £100,000 and it's not broken down. So from an accountability point of view, what we want to do is to say we will set an hourly rate that council will work to. They will put their time down and there will be a a detailed demonstration of the work that was involved for what is public money going out. Solicitors do that at the minute.
So,
Council don't.
I'm trying to get where the problem is here, right? So you've already said you don't question the independence and professionalism of the taxi master, right? In other words, that he or she, I don't know who the person is, does a good job. So what you're saying is you remove an element of that independence away from the taxi master in the determination over to the department, and you're creating another role for the department.
The department is, I mean, in terms of a role for the department in that scenario, the taxing master is assessing those bills, so the department will take no role in that. What we're saying is that we have a budget that we have to live within. I mean, the taxing master recently increased the solicitor hourly rate by 53%. We have to live with that, or we have to try and work with that. And one of the things that we're doing is saying, in terms of accountability and transparency about where that extra money comes from, we would need to business case that and do an economic appraisal of that. That hasn't happened in this instance because the master has taken a decision, as he is rightly within his rights to do, because he sets rates for every case in Northern Ireland, not just legal aid. But what we're saying is that we need to introduce some level of accountability and transparency for the department's budget. So we're saying is that the master will continue to assess and bring his expertise, but
right,
we will have.
I'm trying to get where you're going here, but you've already said the tax master is efficient, is independent, yet you introduce the accountability and transparency to it. Now, where I'm going with that thread of argument is that there is an absence of accountability and an absence of transparency. Now, is that a statement the department's making in regard to the decision making of the tax master?
The original rationale for the PAC recommendation was the principle that when people are taking decisions about the expenditure of public money, that they have to be accountable eventually to the Assembly for those decisions. The taxi master is currently taking those decisions as an independent judicial figure and isn't answerable to the Assembly for how to take those decisions. So the rationale in the end for allowing the department to set the rate at which these bills are paid rather than have that done by an independent judicial figure is that those setting the rate, the Minister and the Department of Justice, will be answerable to the Justice Committee, to the Public Accounts Committee, for how those decisions about public expenditure are made. The assessment of the bills remains with the taxing master, but the idea is that it'll be done in line with rates that have been set in a way that's accountable through the normal mechanisms to the Assembly.
I'm puzzled by this, and I'm still intrigued and puzzled by this. Does the department never meet with to discuss the taxation issues of legal costs with the tax master?
Yeah, we met with him last week. Yeah,
We met with him Friday week ago. Yeah.
You just won't meet us.
Sorry?
You won't meet us. We've
Oh, well, it might meet us, but that's another question. If that's true, Deirdre, well then that would be. I'm only a novice to the committee here, but
a crucial difference in that specific respect is if this committee wants to say why is the rate at which solicitors are paid for doing this High Court work £155? If the department has set the rate, you can call us here and ask us the question, why have you set it at that level? If you want to ask the taxing master why they've set it at that level, they're under no compunction to answer you. And so there's a breakdown then in accountability for public expenditure to the Assembly.
So you're saying that the tax master isn't accountable to the Assembly, won't make themselves available to
whether
the
they
Assembly.
make themselves available or not, and the committee will know better than me whether that's generally the case. They're not required to.
But they're not required to. But what are you suggesting? What mechanism are you suggesting then?
A very simple construct for us is, at the moment, if I can compare both, I'll do it this way. At the moment, the tax master has the power and has exercised his power to set an hourly rate for solicitors at £155.
Yes.
That was announced in April. And then further changes to interlocutory fees. We were involved and made submissions in terms of the impact that would have on the public purse. Something about £20,000 conservatively a day. We don't know what the master took into consideration and didn't take into consideration. It's a matter for the master to do that. It's an independent role. We can't explain the £155. We've some thinking behind it. We know how much it works out at. We know the taxing master. We're not aware, if the taxing master in conducting that exercise has considered impact assessments, statutory impact assessments, the impact on citizens for that rate, because it doesn't just impact on solicitors. As John has said, we are not able to explain that to PAC. We can't explain that in our budget. We know the impact, but we have no say in that.
Right.
In terms of the taxing master's next role after that, he assesses the bills. The comparison is all we're simply doing in the construct is saying we will work with the profession to set an appropriate hourly rate with a reasonable profit margin that will apply to the vast majority of cases. We will work with the profession to apply a rate for council, which are, there's a number of council rates already exist in government levels, and that will be the base rate that they apply to their bills, and the bills still go to the taxing master, and the taxing master's expertise at looking at whether those bills are excessive or otherwise in terms of the hours claimed. That's, I wouldn't know if it's 100 hours or 50 hours. We'd have to create a whole new industry around that. So all we're doing is doing what we are obliged to do for every other legal aid remuneration, which is set fees based on criteria set in law, accountable to the committee, accountable to the Assembly and the Minister, and all the accountability mechanisms. That's what we see as moving back into the department.
Just one question to round this off. Did you ask the taxing master these questions that you've just raised there?
I had a really, really constructive meeting with the taxing master Friday week ago. Chris had met him prior to that sometime before. Mm-hmm. I think it'd be unfair because he is an independent role. He isn't endorsing one thing or the other, but he understands. I took it he understood the rationale. But I wouldn't dare to presume to say the taxing master says it's a good idea or a bad idea. He won't stray into that territory.
Okay. Thank you for that. Just piggybacking on that, Chair, then I think, albeit it may have been the case the taxing master didn't acknowledge or didn't give an intention to attend the committee, I think it'd be useful to hear just if he was as forthcoming with issues and opinions around it, to hear from the taxing master, if we could offer an opinion, and from him, I presume it's a him, and maybe invite him along to the committee, if that would be helpful.
Okay, I'm in the hands of the committee if they're happy enough to do that. We could ask him to provide evidence on the amendment to the Justice Bill.
Chair, the taxing master and through the LCJ's office, I think actually has provided some information on what's in the bill already, and I think they made it clear that they don't particularly want to comment on policy as such in that way.
And they might want to declare an interest, considering the amendment specifically targets actions that the taxi master takes on.
I don't want to presume about putting words in his mouth, so it would be helpful if we heard from himself.
We can certainly scope out and ask and request and see just what the parameters could be. Yeah. Okay, is that you finished, Patsy? Yeah.
Thank you.
Connie?
Thank you.
Yeah, thank you for coming in today. One of the concerns I have really is, in regards to legal aid, is the experiences of those who are victims of domestic abuse, particularly in how they access legal aid and how the waiver is being used. And I think organisations such as Women's Aid have reported that they see that that's being underused. But I'm very interested in what you said in your opening statement around weaponisation of legal aid, and I wondered if you could speak a bit more to that for us, please.
Right, Connie. I'll pass to John, who's leading on this, both on the structural reform on financial eligibility, the means test, and how that then links to the support that we're providing for domestic abuse victims and other vulnerable groups, and the carve-outs, the safeguards we're trying to inject. And when John's given you a better explanation on this, I'll come back just to explain what we're also trying to do in terms of engagement with Women's Aid and MAP and so forth to try and develop this, because this really needs to be carefully worked through, and their involvement is pivotal. Yeah. But John, I think you could.
Yes, absolutely. Thank you for the question. You'll get much more, the committee in general will get much more detailed information on this with the written briefing that's coming next week specifically around financial eligibility testing and merits testing. But essentially there are three issues that we've picked up in respect of the current legal aid provision that are continuing to cause significant issues for victims of domestic abuse, and you touch on all of them in your question. The first is the effectiveness of the current waivers around non-molestation orders and Article 8 proceedings, which have been, the uptake of which is not low, it's vanishingly low. It's proven very and frustratingly ineffective in getting people access to what they need. So for that reason, you'll see that we've got specific measures in the paper that you'll see next week on financial eligibility to radically simplify the tests that apply in those for domestic abuse victims seeking to access a range of legal services. But the particular point that you touch on of the weaponisation of legal aid to perpetuate abuse, we are continuing to see an issue of especially repeated applications for contact with children by abusive ex-partners against their former partners and victims, and the paper will therefore include specific new measures for incorporation into the legal aid merits test to prevent both vexatious applications and repeated applications for contact with children, with the specific aim of addressing that particular issue. But the full details of that you'll see when the briefing paper comes for consideration next week.
Just conscious John has a heavy cold, as you can tell.
Running out of oxygen as well, sort of stuff.
If
you want to know more, if you have specific questions about it, I can't say more. It will pain me slightly.
I'll jump in here to save his voice.
Thank you so much.
I mentioned the wider support because the first thing in terms of structural reform for us is trying to get people who are the most vulnerable getting immediate access. I've lost count the number of times I've heard from solicitors and citizens that are saying the process of applying for legal aid is cumbersome, complex and off-putting and challenging. So hopefully what you'll see next week is an aspiration and ambition in those reform proposals to absolutely cut through that and make it simple. We have to have some sort of financial eligibility test to start off. But for domestic abuse victims and other vulnerable groups, we're looking to actually not so much waive those, but say if you've got evidence that you're a victim of domestic abuse, you go straight into your merits test. You're not worrying about asking someone for bank accounts and this, that and the other thing that'll land it straight in, because they are challenging. I spoke with a very helpful discussion the other week with the Victims Commissioner Designate, and I actually suggested we're taking up the suggestion of setting up a working group with Women's Aid, Men's Advisory, solicitors that are involved in this space that are really dedicated and passionate in this space. Academics, Queen's University will be involved because they've done a report for us in the past, so that we can develop an even more enhanced wraparound model. So not just looking at the weaponisation, but also developing, well, if someone in that space needs help, they're going to one of those groups, they're going to the solicitor, can we wrap that up and use our money more effectively to give them a better service at the point of need and cut through some of the bureaucracy that genuinely exists, be accepted. So that's, hopefully you'll see that next week, and John and I will be happy to come back and talk about this at length because it's probably the more progressive side of the legal aid reform and much needed in that space.
Yeah, I thank you for that, and I think engagement with those organisations like Women's Aid, Men's Advisory Project and others who support victims and survivors, I think is really, really important when it comes to this. And like as a committee and an MLA, we've heard reports from people, especially through the family courts, about how they're finding that process traumatising. And I wonder if there's more you can speak to around any further reforms that are planned to make that as victim-centred as possible.
Challenge at the moment for me to say the detail on that, because within the programme we have proposals to look at reform on working with other areas with the judiciary and so forth, and reform of the family courts and work that's being done in that space, and we're probably more in the space of trying to enable that because legal aid will come in to support individuals, and our aspiration the whole way through this is keep it simple. I'm a very simple individual at the best of times. I could not explain to a man or woman in Royal Avenue what the financial eligibility test now, and I'm in post 4 years. They're that complex and overlapping. And I think once somebody's in the funnel and getting into the system, that's the legal aid bit done. but what are we doing to support those individuals the whole way through? So some of our work that we're looking at will be working with the profession to look at the quality standards and redress mechanisms, and building on their codes of conduct and working with the profession to say, can we do more on CBT training for trauma-informed approach, so people are getting individuals that are understanding what's actually happening with those individuals. So it's a broad sweep, probably not a precise answer as you were hoping, but work in progress, I think, is probably the best way to describe that at this point.
Yeah, I mean, in terms of the aspiration, the thing that you're right, the thing that we have heard is people's experience of the family courts is very often fairly negative, very negative. It can be a form of exacerbation of the trauma that they've experienced. And at present what we offer legal aid, is we offer a lawyer to help you with your problems. So I think that what we would prefer as a system is when someone is a victim of domestic abuse, they'll approach someone for help. Sometimes they'll approach a GP, sometimes they'll approach Women's Aid, sometimes they'll approach someone in their community for help. And what we want to see is at the point where they make contact with someone seeking help, that the services that they require move towards them and come around and around. And as part of that, what we envisage is a new form of legal aid certificate that says, you as a victim of domestic abuse, firstly, we accept that you are a victim of domestic abuse, we believe you, and secondly, as a victim of domestic abuse, as a complainant in criminal proceedings, as a separating partner, as a parent, there's a clear set of legal services to which you require access, and we can grant that access right away, but we grant it in a way that it's embedded within the range of services that are available to a person, including alternative dispute resolution and mediation and so forth for those who are available. So the people aren't automatically directed into a court processes that might not be the most helpful route for them. So the help that is required and that best fits the person's needs at the point of need is the aspiration, and the only way to deliver that is in partnership with community and voluntary sector organisations, public sector service providers, frankly everyone who's in communities providing support services needs to be in a partnership there, so the two strands are together. So a simpler, faster legal aid application process that gives you access to what you need, but also integration with the other support services within communities. That's the aspiration, and the plans you'll see next week are the legal aid part of that plan.
Okay. Thank you, and I appreciate your comprehensive responses. And it goes a lot wider than just access to legal aid. The issues around this around family courts, and hopefully we can have you back to talk about that.
More than happy to come
in the
back.
future.
Thank you.
Just obviously no surprise the taxation master, and I know Christy you've been in before. It's just clarity, because it is difficult to understand when you don't know the process of the taxing master on the one hand, and then what you're trying to achieve on the other. Is that open and transparency, and how the department will go about setting that rate of an hour, and then the taxing master will then, what's his role, just saying how many hours? So does that reduce his responsibilities and what his current duties is, and is that going to evolve and change? So if you just give us kind of some clarity on, and then it's going to be through an amendment in the Justice Bill. So because we don't know, it's difficult to grasp the reasons for doing it in the first place. Mm-hmm. If it's working, why try and fix something that is perceived to be working, other than not exactly known as an accounting officer within the department, how it's all broken down. Mm-hmm. So just for the sake of clarity, where he's at regarding setting the rate, how's the rate going to be set, and then what will be the impact on the role of the taxing master and his duties? Will they be reduced? Will it be less? Has he got less to do? Is his duties now less? Will his role change? You can give us some clarity around that.
I'll start, and then you can get into the details, because you're right across it. I think on setting the rate, it's probably one of the converging points about all of the legal aid in terms of what we've been doing with Judge Burgess, because Judge Burgess in his report had said there's two building blocks to setting fee levels. What people are being asked to do, how long does that take? That's one building block. And how much are you paying for that time? and setting an RE. So we're doing a lot of work, and has been a lot of work done through the working group in terms of looking at RD rates. Solicitors have presented a report for the taxing master on what would be an appropriate rate. So we've quite a bit of work already done on that. So in terms of taking forward the RD rate, what we're planning to do is look at the existing information that we have that's informed some of the discussions to date. There have been reports presented by the Law Society on what would be an appropriate rate for cost of production, what is the profit margins attached to that, and so forth. We have also commissioned a separate report from Strategic Investment Board advisor. We got that in July, just to look at some of that information to say, what is the methodology we should be doing? So we want to really get a good grounding in that. I think we're probably closer on moving things forward with the solicitors because they operate on a time and line bill with an hourly rate, and they break their bills down into minutes. The brief fee doesn't lend itself to that at this point. So we're planning in the new year to engage with the Law Society and the various associations. We met with them a couple of weeks ago.
Yeah, 2 weeks ago.
A number of the Law Society were kind enough to organise a number of the practitioners to come in, and we're giving them an update, high-level overview, and we're committed to working with them through developing an hourly rate with a reasonable profit margin. I think where we landed was that we won't probably have a difficulty on the cost of production element. We'll probably have quite a few healthy debates about what a reasonable profit margin looks like. But in terms of process, we'll break out our information and analysis to the Law Society representatives, and we will get involved in a process of where's the lines of disconnect, how can we join those together. We'll make proposals and we'll go into an iterative discussion. On council fees, there are government legal services rates anyway at the moment, so many of the bar apply to become members of the government panels, the A panels, the B panels, the senior panels, and there's a set fixed hourly rate. It's just recently been reviewed by the Department of Finance there in April. So that's just a good starter for us in terms of, well, that's what government pay council. And in some of those cases, I mean, I'll give the example I've done before. If you go into a judicial review against the department will pay for counsel out of the government panel rates. The applicant's counsel will provide a brief fee to the taxing master. They're apples and pears in terms of what's being presented. But our simple view is a good starting point is we're paying government lawyers to be in a same case with the same number of files, same number of papers, same number of time in court. It's not too bad a starting point to start discussing with the bar and the associations. Does that apply? We've already agreed in principle in the criminal space that the government legal rate should be used as the basis for revaluation of any remuneration levels in the criminal legal aid space. So I think we've made some inroads. Your second part in terms of the taxing master. So I'll pause because if I was, there's a lot of information.
No, it is very complex and it's still not clear, to be
Right.
honest, where you're at in this and how it's going to work out. So that's why push forward on legislation when we don't know where we're at, and we don't even know where we're at and where it's going to end up. If it was black and white, this is the rate, this is what's been agreed, this is the legislation, we're going to do secondary legislation to implement it, that's fine, but it's just that...
All right, I should have covered that because the amendment that we're tabling in the Justice Bill is an enabling amendment to allow us to create secondary legislation to set the rates.
Yeah.
So the amendment that you hopefully be considering in the new year is just to allow that enabling provision to come in. Alongside that and in parallel, we'll be working then to develop the secondary legislation to say this is the rate that we're striking and how we got to that point, which will be subject to all the scrutiny. So in looking at the amendment, the Justice Bill, you're giving us the powers we're looking at getting the powers to actually set rates through subordinate legislation, but that'll be subject to all of the scrutiny, public consultation and all the safeguards that the Assembly and the procedures bring with it. So we're probably very early to say to you how we're going to go about doing the rates. We know what our starting point is. Where we end up and how we go through that, we'll work with the Law Society and the bar to actually develop an engagement process on that.
Yeah, so it's going to be a long,
the amendment,
drawn out process in the sense you're talking years rather than...
We're currently aiming for the end of the mandate, so the primary amendment to go through in the current Justice Bill. As Stephen said, the secondary legislation to be produced in parallel with that. And we do have the power to set, the remuneration order gives us, we can set rates. The enabling provision and that provision is with the Justice Bill team. Subject to the views of the committee, we will then engage. They will engage with Office of Legislative Counsel to take on board draft instructions to look at that amendment. But what that amendment is saying is that these rates that we set in the remuneration order, the master will apply in his assessment. So we can set rates in legislation. It's just that extra bit of assurance that the master will then have to apply those to a legally aided case. And as the secondary legislation in parallel with the aim of the end of the mandate, and the operational side of that all to be worked in as well. In terms of the impact on the taxing master, I think if you take it what is happening now and what we would like to achieve, when it comes to solicitors, they time in line, that's absolutely correct, and we have lots of detail on that. The BDO report that was done on behalf of the Law Society that informed the new hourly rate did not look at profit. So that hourly rate was set as that is what they say is the cost of production. So if we charge that, we make nothing. The profit element comes from the uplift, and the uplift can be anything, and that's truthful. It ranges from 50% up to 200 to 300%. And what we're saying is, for the public purse, what is a reasonable profit? We want to introduce an hourly rate and an element of a percentage uplift, and that is what is applied to the vast majority of solicitor bills that are being paid through the legal aid fund. So that we're not in a situation where there's 200% uplifts being sought from the public purse. It's and as Stephen says, that's where the conversation will be. What is the reasonable element of it? In terms of council,
just on that reasonable end of it, and if you're trying to do it across the board, what's reasonable for a large company with loads of barristers under this one big company, and maybe single smaller companies? Obviously the profit would be different, profit margins would be different.
Yeah, I mean,
so you're trying to standardise it across the board?
Well, but they've already, technically that is kind of done anyway, because even the rate that they've set for
include all their
now, they've had to do a survey of solicitor firms. Some will do better out of it, some may not. So yes, unfortunately we have to talk in averages. We can't be distinct to every firm, but it's the reasonableness of it. And in terms of counsel, at the time, as of now, they submit a brief fee. We have no further breakdown of that. What we're proposing is an hourly rate where you set out what I did, how long it took, and that comprises the work that I've done in this case. They do it, as Stephen said, on the government side in terms of government rates at an hourly rate. And then the overarching thing for both is that we have this data on LAMS, and that data is now accessible. The taxing master's office is a paper-based office. My team went in when we first came into Taxation Reform to look at it. You're going through lever arch files to try and extract information on this. What we want to get into is a position whereby this stuff is how many hours is a judicial review, how many hours is an Article 8 children order case, and being able to get population level data that can then lead to further reform in the future, whereby we can then start to talk about standard fees. Standard fees have been in criminal legal aid now for over 20 years. We haven't made the same inroads in terms of the civil side. So it's about getting that data in, and having that data accessible is the main thing.
Yeah. I'm conscious that taxation, by its very meaning, it is sometimes almost impenetrable to understand all the nuances of it. If it would assist the committee in terms of in advance of your consideration of the amendment, well in advance of that, we provide a more, I won't say detailed paper, but a paper that tries to just break down all of the component elements and provide some examples of how each of those elements currently apply. Contrast with what we might, just to give you a before and after.
Yeah, that'd be very helpful, but we are running out of time, I must say, with regard. Do you have any date with regards when you're going to launch that amendment?
As I say, the instructions, drafting instructions, we will go to OLC end of the month.
There have been no instructions yet?
We have the draft instructions with the bill team. They're putting them to OLC. I think we're in a line, is the simple way to think about it. We're in a queue. But I was in touch with the bill team, and they've advised that end of the month I think there's a couple of amendments that the department are considering for the Justice Bill, and they will go to OLC then. As soon as we can get an indication of what that amendment looks like, we'll provide it to the committee. Yeah.
Problem. Brian?
In the paper, we're told the new approach aims to increase transparency and accountability for public expenditure. If I heard you right earlier, you were saying that solicitors do provide time and line justification, but counsel, I don't know, do you mean barristers, tend not to?
That's right.
That's the current practice.
Mm-hmm.
So will that change, given that there needs to be a justification for claims from the public purse?
That's one of the changes we're introducing, that barristers will be expected to provide time and line bills based on whatever hourly rate's been set, in the same way as solicitors, and then the tax master then can consider those bills, and we'll be able to see exactly what hours have the breakdown of the hours, what the tax master is allowed for, and on foot of his order we will pay. So we will bring both sides of the profession into the same space.
And when we're getting a you were saying about the old rate and the new rate, can we get a comparison with rates elsewhere, other jurisdictions, just for comparison?
We will do. There are certainly on the taxation space. I know Chris has got quite a bit of detail, but we will present that in the update as well.
Just to give us an idea that they're in keeping.
Yeah, more than happy to do that.
Do you have any sense of what percentage of, maybe it's too general a question, but what percentage of cases get legal aid? In courts typically.
Probably be easier to say that in terms of the spend on legal aid each year. So spend this year is anticipated to be 120 million for the whole legal aid budget. Last year we spent just short of 40 million pound on taxation, was ordered through taxation. So a significant portion of the legal aid fund is ordered through taxation. So I'm not sure that again precisely the answer, but you're talking about what's that? A third of the legal aid spend is ordered through taxation, through rates that we don't set, through brief fees and so forth that the taxing master. Again, no criticism of the taxing master's role. I think going back to the PIC recommendation, it was recognised that the taxing master at that time and since provide a valuable role in terms of adjusting bills.
Okay.
No other members, so it just remains for me then to thank you very much for your time, Stephen, Chris and John. Thank you for your time here and the way you've answered the questions. And John, I hope you make speedy recovery.
Next week. Your views on the papers. Thank you very much.
Thank you very much for coming. Yeah. Members, if you are agreeable, I would like to adjourn to give you guys a comfort break, but also then to change the top table, if that's okay. Agree to adjourn? Okay, just for a brief minute. Okay. Suspend. Get the technical jargon right.
Committee Room 30. Sound. 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 Committee Room 30. Sound.
Thanks very much, everybody. So we're now moving on to item 6 of the agenda, which is the Justice Bill written papers, and just to refer you to pages 299 to 302 of the pack, which obviously contains a response from the department to the proposed biometrics related amendments in the bill, and also issues with compatibility of the Windsor framework. And just to inform you that the department is advised that it's satisfied with the proposed biometrics related amendments and that they do not diminish the rights protected by Article 2. The department has also highlighted that there's a legal uncertainty as to whether the data protection constitutes a right, safeguard or equality of opportunity matter under the Belfast Agreement. However, it is the view taken that issues surrounding data protection do apply. The department is satisfied that there's no conflict between the proposed amendments and the regulations with regards to that. So it's just to ask if any members have any concerns or responses pertaining to the department's response. No, if not, I've one issue I suppose I would just like to know, because I think there is a contradiction between on the one hand they're saying there's legal uncertainty in terms of data protection and whether it constitutes a right or safeguard, but on the other hand they then say the department is satisfied that there is no conflict. So I would like to know what the Human Rights Commission, have the department consulted the advice of the Commission and not just the Departmental Solicitor's Office? And if so, what are the Commission saying? Because if you remember when they came in earlier, some of you may not because you weren't here, when they were given their evidence on the bill, the Commission themselves have set up a whole section around the Windsor framework. So they have split the Commission in two and they have a Windsor framework function. And if you also remember last week, in terms of evidence at a Westminster NI Select Committee, I think it was the chair of that committee had raised concerns with the Crime and Policing Bill and its compatibility with the Windsor framework as well. So I would just like certainty if members are agreed that we ask the department, have they engaged the Commission and what their views are on that. The other bit then around the part, so we're satisfied with that. The other part then was around the Department of Justice response in terms of DNA fingerprint, and this is the review mechanism in terms of the biometrics. So pages 303 to 309 of the pack, and the department they respond to questions that the committee have asked regarding the review mechanism and the new DNA fingerprint retention framework as outlined in part 1 of the bill. Just to remind you that the committee asked the department to confirm if the Human Rights Commission, the Commissioner for Children and Young People and the Information Commissioner, if they were all content with the review mechanism, as well as further information on a number of areas related to the review mechanism. So it's just to see if members have any queries or questions with regards to that aspect of the response. No, I do, if that's okay. Sorry again, members. So I suppose the first thing was, I think there's an outstanding query around if someone is requesting their data to be deleted, the PSNI make the first port of call, they review that. But in a case if they review that and say no, and then if there's an appeal to that, the police do that again. And if they say no again, they're adhering to the same position that they're going to retain the data, can that individual then that still requests deletion, can they go to the new commissioner that's going to come into post? So I think that query is still outstanding. I think we asked that a while ago, Kathy. And then the other issue that come up in the department's paper is around the commissioner, the new biometrics commissioner that's proposed in the bill, being unable to make decisions where there's matters of national security involved. And for me, I would like clarity on, well, could the commissioner not be DV vetted so that they can look at these issues, just like the human rights advisor on the policing board, for example, that is DV vetted. So if members are content, could we even just ask those questions of the department around if a commissioner is being created, could they potentially be DV vetted so that they could look at these issues in the round?
Yep.
Are members content? Okay, thank you. Moving on then to 6.3, which is the Northern Ireland Policing Board. So this is a response regarding community resolution notices on page 310 to 313. And again, it retains a response from the Policing Board being referred by obviously Alternatives and Community Restorative Justice in terms of accredited organisations. So just to inform you that the Policing Board response highlights a number of ways in which they are monitoring the use of community resolution notices on an ongoing basis. And obviously we have shared information with Alternatives and CRJ and will await their responses. But are members happy to note the information, or is there any other points of clarification you need? Noted. Okay, thank you, members. Moving on then, just to 6.4, which is the Justice Bill request for further information on page 314 to 350. So just to remind you that that is the table of outstanding queries and questions that have been answered that the committee have been asking. So just asking you to note the list of requests and responses. Noted.
Yeah.
Thank you, members. Item 7, which is the Crime and Policing Bill, LCM, on pages 352 to 356 of the pack. So just to remind you that at our meeting on the 20th of March this year, we received an oral briefing from officials in the department just around an LCM that was coming, including clause 138, which was concerned around GB driving licence information and due to ongoing policy development between the department and the Home Office regarding local commencement arrangements in respect of clause 138. The Minister of Justice removed the provision from the first LCM to allow that policy work to continue and to be completed, which members were advised of in an oral briefing on the 29th of May. Again, just to inform you that the department has advised that the Home Office has now formally responded to propose a revised approach under the commencement of the regulations, which should require the consent of the department insofar as the regulations and the code of practice relate to devolved bodies. So that's where they will consult with them in terms of that emerging code of practice. The department also advises that the PSNI will continue to be able to use the GB driving licence data for road traffic purposes, but any wider use will depend on the commencement of the regulations here and on the PSNI being bound by the code of practice as well. Again, to inform you, the department has advised that the Justice Minister considers that this revised approach provides an additional safeguard and greater influence for the department in terms of the commencement of regulations here in the north. The Minister will therefore is content to seek executive agreement for the second LCM, which will include this measure. So again, it's just to ask if members are content with this revised provision. He's content? Yep. Okay, thanks very much for that. Again, the LCM on 7.2 of the Crime and Policing Bill, and this is around the removal of clauses from the second LCM. So again, just to remind you, the department has provided further updated advising clauses to be removed from the second LCM, and these relate to clauses 31 to 35, which concern strengthening age verification requirements for offensive weapons. The department have advised that the opposition in Westminster has indicated that they will oppose the amendments as they are linking the power to specify other methods of age verification with the government's plan for a digital ID scheme. By convention, contested amendments are not made at Lord's Committee stage. However, the Home Office tables the amendments again at the Lord Report stage. The department has advised it may take the opportunity to progress a third LCM for this as a set of provisions only. So if you're content to note the department's update and any further information or clarification that is required now, we can ask for that, or are members happy to note? Yep. Noted. Okay, thank you. Moving on to agenda item 8, which is the SR on the County Court Amendment Rules 2025 on pages 358 to 396. And again, at our meeting on the 16th of October, the committee agreed that it was content with the proposals for Statutory Rule 2025-171, the County Court Amendment Rules, Northern Ireland 2025. The rule will amend the County Court Rules 1981 to make a provision for the implementation of recommendations arising from a review conducted by the County Court Rules Committee in 2024, which concluded that a general increases of 23% to the fees were necessary to restore them to an equivalent value of the fee that was payable in 2017. The proposals also include an increase of 32% for travel entitlements, as there has been no increase in these entitlements since 2013, a new fee of £75 for any necessary affidavit for which a fee is not otherwise available, and a modest increase to a range of fees for various administrative purposes. Again, the rule is subject to negative resolution procedure and will come into operation on the 26th of November 2025. And the Department has confirmed that there's been no policy changes to the content of the rule since the proposal was considered by the committee, and the Examiner of Statutory Rules had no comments to make on the technical aspects of the rule in her report on the 13th of November. So it's just to ask members if you're content with the statutory rule. Content. I'll put the question then that the Committee of Justice has considered SR 2025-171, the County Court Amendment Rules, Northern Ireland 2025, and has no objection to the rule. Is that agreed?
Agreed.
Agreed, thank you. Agenda item 9, SR 2025-173, the damages for bereavement, variation of some order, Northern Ireland 2025, again on pages 398 to 405. So just to remind you, at our meeting on the 2nd of October, the committee agreed that we were content with the statutory rule pertaining to the damages for bereavement, variation of some order. The rule will increase the fixed amount payable for damages for bereavement under the 1977 order in line with inflation, and this will bring it up to 19,700 based on the Consumer Price Index for September 2025. Just again to inform you that the rule is subject to negative resolution procedure and will come into effect on the 1st of December. The Department's also confirmed again that there's no policy changes in terms of the content of the rule that was considered, and again the Examiner of Statutory Rules had no comments in terms of the technical aspect in her report on the 13th of November. So again, just to ask if you are content with the statutory rule. Content, so I'll put it to the committee that the Committee of Justice has considered the SR 2025-173, the damages for bereavement, variation, some order, Northern Ireland 2025, and has no objection to the rule. Is that agreed? Thank you. I know this is all a mouthful. Apologies, folks. SL1, Police Pension Amendment Regulations, Northern Ireland 2025, on pages 407 to 420. Again, the Department proposes to make a statutory rule under Section 1.1 and 2G, together with Paragraph 7 of Schedule 2, 3.1, 2A and B, together with Schedule 3, 3A and B of the Public Service Pension Act, Northern Ireland 2014, of the 2014 Act. So to inform you that a statutory rule is intended to provide advice, active or deferred members in the 2015 pension scheme for the police who were previously ineligible to apply for ill health retirement for the period the 1st of April 2015 to the 31st of March 2024, with the option to elect to do so from the date they joined the 2015 scheme. It will also make a technical amendment to improve the operation of the 2015 scheme, and the rule will be again subject to the negative resolution procedure. The Department again indicates that it intends to make a rule as soon as possible to provide sufficient time for administrators to make the appropriate technical changes and inform members currently ineligible for Part 3 health retirement prior to the legislation coming into operation on the 1st of February 2026. So again, it's just to ask members if they are content with the proposed statutory rule.
Content.
Members content? Yep. Okay, thank you. Item 11, SL1, Police and Criminal Evidence Order 2025. So again, this is pages 421 to 998 of the pack. Again, just to remind you that the Department of Justice proposes to make a statutory rule under the powers conferred by the Police and Criminal Evidence Northern Ireland Order 1989, PSNI. The rule is subject to negative resolution and will revise the PACE codes A to H and introduce a new code I. The committee has been considering these codes obviously since February of this year, which has included oral evidence sessions from both departmental officials and also the Human Rights Commission. A number of papers, including the full codes, have been included in this week's meeting pack, and members will not have received them in previous pack. A list of other correspondence on this matter is provided in page 428 of the meeting pack, and members should contact the committee team if they wish to receive a copy of any of those items. The committee has also received legal advice from the Examiner of Statutory Rules on whether it is only amendments to the codes that will be approved via the proposed order, or the codes in their entirety. Members are reminded that some of the papers on this matter are marked restricted and should not be shared beyond this committee. To remind us again that the Justice Minister had put forward 2 options in progressing the codes. Obviously, option 1 was to wait on the Equality Commission guidance to consider any amendments required and bring forward a complete revised package of codes, or to put in place interim annexes which make it clear that while under review, it's for the Chief Constable to decide if a person should be treated as male or female for the purposes of search, and the dignity of all parties to be respected. Again, the last committee that we considered these codes was on the 3rd of July of this year. Members set out the position of their respective parties on the proposed changes at that time. I'm conscious that there's new members from some of the parties as well. The extract from the agreed minutes has been included in the meeting pack, so that was just to give you a reference on where parties stood at that time. The Department has now provided a revised draft Annex L to Pace Code C, which will be replicated also in Annex J to Code H and Annex H to Code I, and advised that it has collaborated extensively with DSO and the PSNI on this matter. The Department notes that the PSNI is satisfied with the draft, and the Police Federation has also provided its view that revision seems as explanatory as possible given the complexities that we're looking at. The Department has also reiterated the need to update the codes to reflect the changes to counter-terrorism and national security legislation, and to mitigate against any potential risks associated with the draft codes not being in place. So again, I'm going to seek members' views on whether they are content with the draft codes, or again, which of the options, I suppose, that the Minister had previously proposed, if there are any of those options that you just would like to look at. So again, I'm just going to call Brian. Yeah.
Thank you, Deputy Chair. I've been reading back, as a new member committee, reading back through the previous minutes and the papers on this. Certainly it's a complicated matter. The draft annex does cover a lot of variations in circumstances that could arise. We as a party are still concerned that there isn't the protection, sufficient protection for police officers in the circumstance where they're asked to search someone of the opposite biological sex. There is a line in the annex number 5 that the written consent would be required of an authorising officer, the transgender person to be searched, and the police officer conducting the search. But that's the only reference that there is to the officer who would be conducting the search. There is nothing, whilst it talks about consent, it doesn't talk about the right to decline. Now, later on in the options, page 441, it refers to the National Police Chiefs Council, which does, in that paper, which I'm sure members have seen, in that NPCC guidelines, it says, can an officer or member of staff refuse to search a trans detainee? Answer, yes, and there will be no career detriment to the officer or member of staff. That's the safeguard we would like to see in the guidance. And I mean, we're told again in the paper from the Justice Minister, in practice it is likely the PSNI would follow the NPCC interim guidance, but as this is an operational matter for the Chief Constable, it would not be appropriate to place this on the face of the code. We just think that's too weak. To say it is likely that the PSNI would follow it, but those operational matters couldn't be placed in the code. I mean, the code, or the draft at page 432 that I referred to earlier, does explain about written consent being required from a senior officer and the officer conducting the search. So it does go into practical arrangements. So we still feel that respect, I mean, and there's a lot of talk there about respecting everyone, respecting their wishes, coming to arrangements, some of them quite complicated arrangements. But we feel there needs to be protection for officers, that they're not in a situation where they feel they're being disrespected or made to feel uncomfortable. And we do think that there needs to be that clear specification that an officer can decline to carry the search, that would not be seen as a disciplinary matter, that their wishes are respected, and that there should be no career detriment to the officer. So we would like that matter taken back, referring specifically to that line in the NPCC guidance.
Okay, we'll take that at the end, Brian, then, just in terms of next steps. Ciara?
I suppose just to reiterate our position, that hasn't changed, that we believe we shouldn't wait until we get the Equality Commission update before, or the guidance, and before any finalising decisions on that. And then likewise, just to reiterate, obviously Court Hitchin High in it is draconian Westminster legislation, which we believe breaches the right of citizens affected by their operations, and just to note that.
Thank you. Morris?
Sorry, apologies for getting out. It was that wireman here, I couldn't. I've been in colder saunas. No, just to reiterate and agree with my colleague Brian here, we would have reservations about proceeding now without any further, I think, information from the courts on. I mean, it's still under review, the legal definition of a man or a woman according to sex or gender, biological or. So we would like to wait. No, not happy at all.
Thank you. Morris? Anyone else? Doug? Yeah.
I mean, Chair, I just have to lay out the Ulster Unionist Party position on this, and it's not far away from the DUP. I think it's quite clear. If you look at paragraph 5, it does state that efforts will be made to ensure an appropriate officer or member of police is identified to conduct the search. But what it doesn't go into is, what if they do not find somebody who is able to do the search? Will it be a direction given to do the search? And that's where the protection needs to be in place. Yeah. That if they can't get anybody to do it, nobody wants to do it, then they shouldn't be made to, and that should not be any detriment. So the MPCC guidance, I think, is pretty clear. We think it needs to be inserted before we can support this.
Okay, thank you. Nobody else has indicated yet. So I know there was the two options laid out by the Minister as a proposed way forward. But I suppose on the one hand, I mean, Ciara has highlighted that she would like to see the Equality Commission guidance come forward. I think it would be good even to contact the department on when that's likely to be. Is there an indication? So if we could potentially look at that as a proposal. And then also, I suppose, in terms of what Brian and Doug are proposing then is to write to the department asking whether they would incorporate the MPCC guidance potentially into the codes then. Is that something that could be considered?
Specifically that line, yeah.
Yeah, you have that line, don't you, Captain? Yeah. Okay. So if we await then the department's response, or is there anything else that members want?
Yeah. Just to put on record that our position hasn't changed, and I would have been in favour of option 2, but I understand there's been concerns raised today.
Okay. Chair, just to comment, just from my previous experience on the TEO committee, I would have a very low expectation of us getting guidance from the Equality Commission. I think they're just waiting for a court case, quite frankly, because we sought guidance from my time on that committee. But if we want to write to them and get their response, that would be my concern. I'm not against introducing the right arrangements, the right annex, but we need to get it right at this stage. And there's so much emphasis on the person being searched, but I think we need that line, that protection for the officers as well, respecting their wishes.
Okay, thank you. I think what I was proposing was write to the department first in terms of the Equality Commission guidance, but then also to pick up the proposal that you've made as well. And Doug has come in on, so our members agreed with that, and obviously noting Connie's preference as well. Members agreed?
Yeah.
Okay, thanks very much, everybody. Moving on then to item 12, which is the Police Ombudsman retention and disposal schedule on pages 999 to 1055. Again, just to remind you that the Police Ombudsman for Northern Ireland's retention and disposal schedule is required to be laid before the Assembly under Section 8.2 of the Public Records Act 1923, and in accordance with the rules of the Disposal of Documents Order 1925 by the Public Records Office Proning. The retention and disposal schedule is subject to the negative resolution procedure, and the statutory period will end on the 12th of January 2026. So just to ask if you are content that the retention and disposal schedule for the Police Ombudsman of Northern Ireland is laid. Members content?
Content.
Okay, so just to also seek your agreement to inform the Committee for Communities of the decision on the matter, as Prony falls under the policy responsibility of the Department for Communities. Agreed? Okay, thanks very much. Item 13, the renewal of the Secretary of State's discretion under 1A of the Prison Act as amended in Schedule 4 of the Northern Ireland Act 1998, Devolution of Policing and Justice. So just to refer to pages 1057 to 1079. And again, at our meeting on the 23rd of October, the committee considered a response from the Department to questions asked of its consideration of the renewal of the Secretary of State's discretion under Section 1A7 of the Prison Act. Members agreed to ask the Department for the Secretary of State guidance that the Prisoner Ombudsman is bound by when investigating decisions that touch on national security related issues, as well as for more precise numbers of staff involved in the work which would fall under this direction. Just to inform you that the Department has now issued a response to those questions, in which provides a copy of the guidance issued by the Minister of State at the NIO at the point of devolution for policing and justice matters. The guidance sets out how the Ombudsman should act when investigating decisions that touch on national security related interests. And again, the Department response also states that 10 prison staff are impacted by this direction. So again, it's just to ask members if you're content with the information that has been required and received at this point.
And
Members are content? Okay, thank you. And just to remind you that the original paper from the Department had stated that the Justice Minister is of the view that the direction remains fit for purpose, that it does not need to be amended, and that if it should be renewed from November, but that the Minister would be grateful for the committee's view. So again, I'm going to ask if you're now content that the direction is renewed, and to seek members' agreement to advise the Department of the committee's position. Are members content?
Yeah, there's just kind of one question in terms of the Prisoner Ombudsman removing details from reports under the direction of the Secretary of State. Does there have to be a specific rationale given by the Secretary of State to the Department of Justice, and what's the criteria around that? Just how does it happen?
You want that just as information?
Just as information.
Okay,
yeah.
so people are happy to agree it today, but we'll get that further clarification.
Yeah. Yes.
Is that okay, members? Okay. Thank you. Moving on to item 14, which is the correspondence, and just to inform you that there's a memo for the correspondence and 9 items of correspondence from pages 1079 to 1166 of your pack. I would like to draw your attention to 7 items within the pack. So looking at item 14.3 on page 1087, which contains a response from the Department to questions the committee had asked regarding an alleged incident at McGilligan. Again, to note that one of the questions asked by the Department related to the committee being kept informed of serious incidents, which the Department acknowledges would have been done by the previous Director General of the Northern Ireland Prison Service on a case-by-case basis. The Department's response states that the Prison Service wishes to revisit how the chair of the committee can be kept informed of on a similar basis going forward, and has suggested that a meeting between the committee clerk, the DOJ DALO and the prison officials is set up to discuss how an effective approach can be agreed. So it's just to ask if you're content that the clerk meets with the DALO and the prison officials just to progress that. Are members happy? And then I'm sure there'll be a mechanism then to inform the committee then once the chair is informed. Okay, on item 14.6 on page 1157, so this is Dementia NI Member Forum in relation to provision of lasting power of attorney under the Mental Health Capacity Act. So again, just to inform you that the forum has highlighted that the Mental Capacity Act implementation project has been established with the task of putting lasting power of attorney in place, and ask the committee what the committee is doing to scrutinise the work. So again, I'd just like to seek your agreement to forward the correspondence of the Department to request an update on the work of the Mental Health Capacity Act implementation project on the implementation of this provision. Our members agree that we communicate with the Department?
If I could just suggest,
Yes,
I remember
Patsy,
then there was an ad hoc committee set up and it straddled both health and justice. So if it could be an idea maybe to get an update from health as well about how this is impacting, if that'd be okay.
Yeah, we can
Aye.
communicate with both departments if that's okay.
Great,
Are
thank
members
you.
content?
Yeah, could we include in asking the update for timescales on implementation or any issues that are outstanding, and then what further engagement, if any, that they're planning to do would be useful
Members
as well.
content with that? Yeah.
Mhm.
Okay. Thank you. Okay, moving on to 14.7 on page 1159. So it's correspondence from the Northern Ireland Humanists in relation to the continued existence of blasphemy laws here. And again, it's just to ask members if you're content that we'll forward the correspondence to the department and ask what consideration, if any, is being given to repeal blasphemy laws. If members are content that we write. Agreed, thank you. Page item 4, 14.8 on pages 1161. It's correspondence from an individual regarding legislation around the sale of fireworks. Obviously this came up in the chamber this week. And again, correspondence makes reference to the increasing evidence of fireworks being sold and used illegally, and that the current legislation would benefit from a review. The individual has also raised a number of questions they would like clarity from the Minister pertaining to this matter. So if you wish to respond, the individual highlighting the debate obviously on the 18th, or I suppose can we forward the questions on? Yeah. If members are content that we forward.
The committee thinks it should be a review.
Great.
And obviously we can give them an update. They can tune into the debate that we had for the motion. Okay, so you are content with that then, thank you. 14.9, refer you to page 1163, which contains correspondence from an individual whose son tragically died along with 2 other young people at the Greenvale Hotel tragedy in March 19. I know this was referenced earlier in the meeting, and the individual has requested to meet the committee in order to raise concerns about the delays in the legal case around those charged in relation to the incident, as well as a lack of progress in communication. Again, to advise the case is sub judice, so members are advised to use caution when discussing the matter in order to protect the integrity of those ongoing judicial proceedings, and just to seek your views on how to respond. And I would agreed earlier to engage the PPS, the Lady Chief Justice and others looking at delays, because obviously that's one of the key concerns. So it's just to see if members are content at this point that we do that initial engagement first, and then we see where we are. I am conscious there is an ongoing legal case, but I understand too that the delay is, I suppose, a key frustration for people. Patsy, yes?
Just on that, Deirdre, Chair, it might be helpful, just in case he thinks we're giving him a blank no, because of the and I know I've been to the houses of the families here, and I know some of the other victims, so it might be helpful if, when those meetings are being arranged, that he and other members of families are notified that the meetings with the PSNI, Lady Chief Justice and others are taking place, so that they could at least hear what's happening and maybe in committee or otherwise want to contribute about that.
Yeah, no, I think we'd be happy to communicate that it's obviously been raised today. I mean, they've lost their children, so yes. I think we'll definitely go back and correspond with them, Patsy, if the committee's agreed, and then we'll just highlight that the issue has been raised in the committee in terms of delays in justice, and that we're going to do dedicated session on it, so we'll communicate that if members are agreed.
Good, thank you. Yep.
Okay, thanks very much. Item 1410, so this is in pages 1164, and it's obviously correspondence from Jerry Carroll MLA in relation to an individual in terms of attending a judicial review regarding the Victim Payments Board. This obviously also came up in one of our last meetings as well, where that individual had highlighted just the ongoing case, and it's been listed. And again, just to seek members' advice, to advise Mr. Carroll's of the committee's agreed position on this matter. I think it would be useful. I mean, I don't know if members that we get the outcome of that hearing, if we can get an update on that, because I think the issue of the victim's pension has come up and many members around the table have raised it. So I'd be keen to see the outcome of the court case, if that was okay. And if we can just correspond back to the individual, are members content enough?
Yep.
I know Jerry, Carl, I think forwarded the details. Okay, items 1411 in your pack, again, which is a press release and serious adverse incident report, which was published by the Prisoner Ombudsman. It's going to be published tomorrow. So members should note that it's embargoed until midnight, or just 1 minute past tonight. And again, just to ask if you're content to note the report, or if there's any further info. Content to note, okay, thank you. Oh, sorry, we're moving on to 14.12 as well, which is on pages 61 to 118. And this is regarding the Criminal Justice Inspection Report and the management of organisational performance within the PPS. So the report makes 3 strategic recommendations and 4 operational recommendations. So again, it's just to seek your agreement to ask the PPS for its response to the recommendations, or to discuss during the oral evidence session that has been agreed. It may in advance, and also that CJNI report notes that close to 40% of the total time for a Crown Court case was spent in the PPS waiting for a decision. So again, it's just to see if members are content that we write to the PPS.
No, it's the right to the department for that.
Oh, aye, sorry. Aye, so are members content, sorry, that we write to the department first, just asking for clarity then? Okay, thank you. And then we can use this.
We've agreed to request PPS to attend, haven't we?
Yes.
Yeah.
They're coming in for an oral evidence session, yeah.
It's good.
So it's really to provide a breakdown from the department of the time taken at each key stage of the journey through the judicial system. So there had been a previous stage breakdown that was provided to the committee. And again, it's just asking for an update on that case breakdown. And then, yes, Brian, in terms of the oral briefing session with the PPS as well, we can use this information. So are members content then that we seek that from the department?
Content, yeah.
Okay, thanks very much. Are there any other items in the correspondence, or are members happy to note? Happy to note, okay, thank you. The forward work programme then on page 1168. So just again, if you're content that the committee's first meeting after Christmas will be the 15th of January, which is the same week that the plenary returns. So just to seek your agreement that the forward work programme subject to change as agreed. And if you wish to highlight, I suppose, if there's any other sessions as well. So we're still, sorry, so are you happy enough then that with the forward work programme?
Yep.
Okay, and then again, just to advise you that next week, obviously, we have an oral evidence session with the PSNI around the Justice Bill. And I know we've penciled one in if we need it again in January as well. So just if we need to use that time. Also, DOJ officials will be in on pre-legislative scrutiny of the sentencing bill. So that's also in the forward work programme as well. Item 16, chairperson's business. There's no chairperson's business this week. Item 17, any other business? Brian, yep.
I don't know if it was raised before. I know there was a media report about jurors not getting sustenance that members might have seen. Whether we can ask, just an ask, what are the rules regarding that? I'm not sure how accurate the report was. I haven't heard anything else said about it, but people might have seen that media report. So I think it's appropriate that we just ask, what arrangements are made for members of juries.
Yeah, we're happy to seek that if members are agreed. Yeah, agreed. Thank you. Any other business, folks? No. Just to remind you then, the next meeting is next Thursday at 2:00. Thanks very much, everybody. Meeting adjourned.
Okay, thank you.
Committee Room 30, sound. Committee Room 30, sound.